one more second. It's not doing what I need to do.
Shannon Render.
All right, we're going to get started. There is one thing I can't get working in here, but I think we can do what we need to do. So we are going to talk about a trial calendar that runs from September 16th, so that's 1 week, through the 27th. That's the second week. So the week of the 16th and the 23rd, we're calling it today to figure out who needs to be here the first week, who needs to be here the second week. By the end of probably this morning, we'll have a pretty good sense of who's still standing. We've maybe got some pleas and some certain I'm going to trial. And we will make sure that we get that list of cases out. So position one is Ms. Shanahan. I don't think she's here yet, but she will be here this morning. Ms. Wood, are you ready to go with Ms. Shanahan? She, through you, have filed a speedy trial demand. And so we have to resolve her case on this calendar, week 1 or week 2. The answer is ready? Okay. Anything changed from yesterday such that when Ms. Shanahan shows up, you need to talk to her?
I will speak with her, Judge, but I don't have like a new offer or anything to convey.
Okay. Would it be helpful for her to hear from me that we'll be going out either week 1 or week 2, or she's aware? Only so that I don't know when I last saw her, but she should understand that this is it. It'll be trial one of those 2 weeks.
Yes, Judge. I will speak with her, and then if she
Okay.
wants to do the court, I'll let you know.
Let me know. Great.
Thank you.
All right. Ms. Gordon, there are family members in 7E. Normally, family members don't show up for the competency docket, but there are some family members for some situation with which you're involved. And a request has been made for you to pop down there to interact with some family members and then come back here. You got a client here and something important here. I promise we won't resolve the case in your absence.
Last time I checked, my client was not yet here.
Okay. Is he in adult custody or juvenile custody?
Adult, he's at Union City.
Okay. I thought all the males were here except for Stewart. But where is her client?
Where are the female Shanahan?
So is it Ware or Stewart, or both of them are not here?
Where?
So Stewart is here?
Stewart is here.
Okay, we just got it flipped around. So your client's not here anyway. He will make it here. In the meantime, if you don't mind going to 7E, that would be great.
Thank you, Judge.
That gets us to Carrie Henderson. Ms. Henderson, are you here? Good morning, ma'am. I'm doing all right. It's good to see you again. Ms. Rios, are you ready with Ms. Henderson's case?
Yes, there should be a plea.
Today?
Yes.
Okay. Ms. Henderson, if you'll sit tight when we get through the call of the calendar, we will, I'm adding you to the list of likely pleas. Okay? All right. Thank you. Co-defendant in that case is Mr. Parks, who's represented by Mr. Rowe. Mr. Rowe, good morning.
Judge, our announcement will be ready for trial subject to negotiation.
Okay. Do you, when you look at your schedule, do you have a preference between that first week and the second week, the week of the 16th and the week of the 23rd? And if we go on the week of the 16th, we actually would pick a jury on the 17th.
Actually, I prefer the week of the,
We'd pick a jury Monday, the 23rd, if we do week 2. I'm not saying we can even do week 2. Mr. Abate has been, the special setting date was the first week, but if his witnesses are flexible, it may be that we do week 2 and we do our speedy trial the first week.
the 16th.
Okay, knowing that the 16th actually won't be here, it would be the 17th that we pick a jury, but your preference is week 1.
Yes.
Okay.
Yes.
Got it. Works for me. Thank you. And then Mr. Menettis, are you here?
Yes, Your Honor. Good morning. I'm here on the Zoom.
Good morning. You represent Mr. Phillips. You're newer to the scene, but you came on board knowing there was a special setting. I know you were working hard, as you always do, to get the discovery, get up to speed, et cetera. I assume you're ready to go. Maybe you continue to talk with Mr. Abate, but you're ready to go for this trial calendar as well.
Yes, Your Honor. I had filed some motions, and then this honorable court let me know those would be heard on the eve of trial. And I'm trying to resolve the case. I just haven't been able to get that discussion going yet. So I'm going to stay on that. And we're otherwise ready. I understand we have all the discovery, but I'll make sure and double check. And we don't have a preference as for the trial week.
Okay, so if we started picking it, well, we'll do it in one day. If we pick the jury on Tuesday, the 17th, that works for you.
Yes, Judge. I believe I don't have any conflicts with any special sets or leave for any of the trial calendar.
Okay, I think we checked your leave, so we should be good. And this is special setting, so it would have to be a really old case to get out ahead of this one, but there are old cases out there. Okay, I am poking my head in the docket right now to see, I just want to make sure I am comfortable with my representation to you that we would handle your motions at the, so you, let's see here, events, filed a bunch, flurry of activity once you came in the case. So you substituted counsel, that's good. Your standard consolidated motions, bond motion, severance. So we'll talk about severance. I got you the order you needed for contact visits. Hopefully that's still working. And that's it. Okay. I do think we are in a good space then to be ready to go either that Tuesday, the 17th or the following Monday, the 23rd. Your client is here and he's been brought up. Do you want to bring him to the door so you can say anything to him, or are you good to go? And Mr. Phillips doesn't need to stick around here today.
Your Honor, I'll see him at the jail, but I do understand his family's here and wanted me to make a out of the ordinary special request, Your Honor, if he could visit with his baby after everybody leaves. I don't know if that's all right with the deputies, but they did want me to throw that out there. And also I was wondering, since it is a motion to sever, if we're doing business on the 16th, I would be open to coming in to address that day, just in case.
Okay.
Granted.
What I will do, I'm going to make a note that we need to work through severance, and I will let you know if we can do something on the 16th or even before the 16th. It wouldn't be a super long hearing, and it's easy enough to get Mr. Parks and Mr. Phillips over here to take care of something like that. So I will look at that and we'll sort it out. Okay.
Yes, Judge.
All right. Who is here for Mr. Phillips?
Yeah. Good morning, Judge.
Good morning. How are you?
Well, how are you?
All right. And is the young lady who that's who you want Mr. Phillips to see?
Yes.
Okay. All right. I'll talk with Deputy Gordon and we'll see. I can't guarantee anything. That's outside my bailiwick. That's a security thing rather than a what's the law on that. So let's see how the morning flows and I'll let you know. Okay. You're very welcome. And Mr. Menettis will keep you posted as to when we're coming back for trial. It's sounding like it'll be the 17th. Mr. Menettis will need from you someone in Mr. Phillips's family clothing for Mr. Phillips so that he's dressed out appropriately for trial.
Okay, we have that already.
Great.
Yes, Judge.
Excellent. I figured you had it. I just was flagging that in case Mr. Menettis will be pretty busy between now and then. And so I wouldn't want you to think he wasn't paying attention to you if he wasn't able to get back to you right away. But that's going to be a critical need is so that Mr. Phillips, same with Mr. Parks. I don't know if there are people here from Mr. Parks, but he'll need clothes and those will need to get to Mr. Rowe, who was in here. Okay.
Yes,
All
Judge.
right.
I failed to ask about that. Should I just bring them with me on the 17th or does the deputy?
No, you get an email. I'll send an email out to all the lawyers, but we'll want them the Friday before and you just bring them by here and either Deputy Gordon will collect them or they'll just go back in my chambers. But they need to get here beforehand because early in the morning on that Tuesday or the following Monday, whenever we start this trial, the deputies get folks dressed out.
Understood, Judge. Thank you.
Thank you.
Take care.
You too. All right, Mr. Tewitt. Is there anyone here for Mr. Tewitt? His lawyer's not available right now, so that is a reset. Dexter McGriff. Mr. McGriff is here. Any word about your lawyer?
He reached out to me and he said it was Zoom.
Yep, I just got a note now. He'll be hopping on Zoom in just a few minutes. And I don't know, Ms. Clark was running late.
I'm right here.
Oh, she's here. Great. Thank you. Not running late here. All right, we'll wait for Mr. Schnipper to get here and come back to that. Mr. Walls has two positions and Mr. Adams hopefully is going to be here soon. Ms. Rios, did you hear, not that you are Mr. Adams's keeper, I just know that you remain affiliated, although, there was an entry of appearance from Mr. Adams. You're out. All right, you're dead to me on these two cases. So hopefully Mr. Adams gets here soon. Did you get a chance? He was going to come see you.
We did. We had a meeting yesterday evening, Your Honor. And,
Was it a productive meeting?
I believe so, Your Honor.
Okay, we need to hear his announcement.
Yes.
Okay, Mr. Walls is up, Deputy Gordon. All right, we will track down Mr. Adams. You're ready for trial, assuming you're not in trial in front of Judge Emerson.
Yes, Your Honor.
And Ms. Wood and Ms. Clark, I don't think I've sent out another email on that front, but the Adams case, which was 2 ahead of you, has been continued. That's Judge Schwall's case, and he said you guys don't have to go till week 2 of the Emerson calendars. So that leaves just, I think Eccles is the name, which is a McAfee case. So you need to talk to your counterparts, if it's a PD case, with Judge McAfee. That's the only one ahead of Wright. And nothing will cut ahead of Wright. So just know what's going on with Eccles. But you all should be focused on that for next week because you're now number 2 on the list.
Thank you, Judge.
Which is totally surprising to me, but that's how these calendars work. Go consolidated calendar. All right, we'll come back to Mr. Walls. Mr. Charles, that is sort of your case, Mr. App. Mr. Weinstein filed an entry as well. Are you guys co-counseling on the Charles case?
He's my associate, Your Honor.
Okay, no, I know of him and the connection, but he had recently, there was some paperwork saying, oh, Mr. Charles came all the way here. Okay.
Yeah, he's here. Your
All
Honor,
right.
I apologize. So I'm not sure yet. We're not sure yet who in my office is going to actually end up trying the case, but I think we're both listed as counsel.
You are, and sadly, you both have the same kind of conflict. Do you have a second associate?
I do. That's Katie Hingerty, but
Okay.
she does mostly appellate work for us. So
Doesn't she miss trials though?
no,
No.
it's not. And she's tried lots of cases in her career and is happy to write appeals.
She's done. Okay, so it's you or Mr. Weinstein. If it's going to be a trial, one of you needs to be available for a week.
Yes.
Okay.
But YSL unfortunately is
All consuming.
kidnapped us for I don't know how long, and
I don't know that it's kidnapping if you get paid for it, but
Well,
okay.
yeah.
So
That's another more complex conversation.
yeah. You remain ready when available, I guess is the
I think
announcement.
that's a fair announcement.
It's not a discovery issue. It's literally an attorney availability. Or if they're discovery issues, let's talk about them because Mr.
Yeah,
Abate's here.
and being candid with the court, we're still going through the discovery, but if something comes up, my experience has been that those can be worked out very easily without the court.
Okay.
I don't know that we'll need court involvement in this case for a discovery issue.
Okay, I doubt it, given the lawyers involved. I think people will say, I need this, and then you get that.
But
And that's where we
those
are.
things will all be worked out. And then, I'm sure the court would like us to resolve motions issues and other narrowing down of issues now, but it seems from a time perspective, that's difficult for us.
Well, you say that, but I have been able to squeeze in, as have a few other persistent colleagues, motions here and there with Mr. Harvey or with you. And so I don't know that there are any pending motions.
There are not, because
Okay.
we're still going through the discovery,
Okay.
being candid with the court.
Well,
So
let's do this then. What will flow from today is a deadline for your team, because while Ms. Hingerty doesn't do trials, she could look at the discovery and say, look at this, he gave a statement and he wasn't Mirandized.
we also have staff that,
Oh, there you go. Yeah, I'm not designating who needs to do that, other than that it needs to get done.
yes,
Because if, for whatever reason, Judge Whitaker were to say, we're going to take a month off from YSL, your dance card will quickly fill. This is a case that has an incident date that is so old, I try to push it towards the front. Who knows how successful I'd be, but I have you and Mr. Weinstein, so it's only need one of you to do that. So what is a reasonable deadline for Team App to get through the discovery and say, we have motions or we don't?
would it be unreasonable for me to ask the court to allow us to get any motions filed by, we're in what, September?
We're in early September, so an entire month.
December 1? Is that,
How about, tell me, Mr. Abate, the discovery in the Charles case, particularly voluminous, or, it's one body cam and some police reports and an autopsy?
The typical amount of discovery for a murder case, nothing incredibly voluminous, but nothing,
It's not a single police report.
no,
Okay.
it's somewhere in the middle.
Somewhere in the middle. Okay. Mr. Charles, you don't have to keep standing. I feel bad that you're standing up.
You can sit
You're
down.
good.
Thanks, Ronald.
How about November, the beginning of November? I'm just curious what you're going to get done in November. So you have all of September, all of October.
I can live with November.
All right. Then let's look.
Maybe not November 1, but maybe somewhere
Okay.
in
Have a hard
November.
bargain. November 11th.
Perfect.
11 November, I will enter an order that says all along the lines of all evidentiary motions. You have your motions in limine before trial. Don't call them killer, whatever it is that you don't need to worry about until you or Mr. Weinstein are getting trial ready. But immunity motion, a suppressed statement, that needs to be filed on or before November 11th, so that then we can start working with Judge Whitaker to say, when are you going to have a day off? Oh, the December 8th will be off. And then we work with your office to say, great, we get 2 hours of your time or Mr. Weinstein's time on December 8th. Okay.
Very good.
That's at least progress, so that
I like it.
when something ends in 1C, whatever ending means in that case, we really are ready to say it's trial.
Great,
Okay.
great. Thank you so much.
Mr. Charles, do you have any questions about anything we've discussed? Okay, you live in New York?
He does, Your Honor, and he came down for today. I would ask if the state doesn't have any significant objection. I mean, he's very responsible. He's in regular communication with me every month. Obviously, he's here. Is there any way we could get him excused from like calendar calls and just status hearings so that he's not unnecessarily flying around the country?
I think that's a fair request.
His address is on file with the court. I mean, and he's.
Judge Vincent Fawcett, that's Charles' case has been assigned to me now.
Oh, because of its age?
Because of the age.
Or just it needs your skill set?
I would say it's because of the age. Just from this applicant, but I'll email you so you can have my contact information.
Great.
And I'll leave that issue in the discretion of the court.
Okay, Mr. Fawcett, great to have you on board. I'm sure Mr. Bate's okay handing off one of his cases. I don't have an issue with that. Where we'll need to navigate it would be, depends on what the motions are. And if they are ones where he's not going to be a witness and you want to waive his presence, there'll always be a Zoom feed so he can watch and listen. But there isn't a reason why with a waiver from you, I don't even mean a written waiver, but one on the record, with a waiver from you, he couldn't participate remotely if the testimony is coming from officers or others.
Yeah,
but that's your call. I don't mind if it's a status event, people zooming in.
Great. So with the court's permission, then I'll have him appear by Zoom going forward.
That can be the default, and I'll make sure I remember that so that if I need it to be different, I let you know and you let him know, actually, this is a plane trip. Obviously, trial is a plane trip. Plea would be a plane trip, right. But hey, how are we doing with discovery? You can dial in for that too.
Thank you so much.
All right, Mr. Charles, it sounds like you're good to go. Mr. Fawcett, anything else on behalf of the state?
Nothing from the state yet.
Okay, thank you.
Thank you, Your Honor.
You bet.
Good to see you.
Same. Nice to see you outside of 1C. Derek Jernigan.
He's my judge. I spoke with him and we are ready for our plea.
Still a plea. All right. Amani Taylor. Hello, Ms. Cabrera.
I don't see her.
Yep, I see your other client, but
Number, I think he's position 2 or something.
he's on our supplemental, Senor Romero.
So her not being here matters.
Yes.
I did file a motion to modify the conditions of her bond.
They'll be modified, all right.
So I won't even get into that at this point.
Okay.
Judge, I actually can make it a little bit easier. The co-defendant, I think, is going to take a plea that should resolve everything.
Right, that was my understanding. So is Ms. Bennett here? Great. All right, so Ms. Bennett is here. Ms. Rios, your case?
Yes, Your Honor.
Still going forward with a plea?
Yes, Your Honor.
All right, so Ms. Cabrera, if you don't mind waiting, let's see what happens with Ms. Bennett. And then I think we'll talk a little bit with Mr. Wooten about Ms. Taylor's case.
And then that might resolve her.
Correct.
While I'm still standing, Mr.
Romero is here, Romero Silva, yes.
Correct. There's something that I know Ms. Nix wanted to do with him today. I don't know if we can work that into this morning. There may be some things that happened with him this morning.
Okay.
Otherwise, we're in the same posture.
All right, well, I'll let you guys talk. I thought there might be some movement in the case, but we'll get to that calendar call. I haven't gotten there yet. But we do have an interpreter online so that there can at least be an initial exchange with Mr. Romero.
Okay, perfect.
All right. Okay, so hopefully Ms. Taylor makes it. You can work your phone on that. Ms. Bennett is here, and that is a plea. Edward McGillicuddy. Good morning, sir.
Morning.
Judge, I need to speak with him. I have a new offer, so if we could do that after the call, otherwise we are ready for trial.
Okay, Mr. McGillicuddy, Ms. Wood's gonna talk to you about a potential non-trial resolution. If that's not what's gonna happen, then you will be back here either that Tuesday, the 17th, or the following Monday, ready to go in the trial of your case. Okay, any questions about that? Good. Okay, she'll talk to you in just a little bit. Ms. Markey, and I'm sorry if I didn't pronounce it correctly. Hey, and your lawyer?
She might be in Truth County. She's on, I guess she's coming. She might be on Zoom. I'm not sure. Walk around.
Yep. Ms. Nelson, had you heard anything from Ms. Brown? No, she says. Can you reach out to Ms. Brown?
She might have tried to call me.
Okay, no, that's fine. Why don't you step out and let us know what you're hearing from her? Thank you. Mackenzie Previon. Ms. Rios, are you ready in this case?
Yes, Your Honor.
All right, and Ms. Clark, you are still waiting on something from the GBI.
Yes, Your Honor. So the GBI, at the last, when this case was on, at the final plea, I filed a motion for continuance. We're still waiting on some GBI results to get back, but there was also additional things that we had to submit based off of the trace analysis. They're wanting it. So they notified us that there were additional things that they needed.
Okay, so help me better understand that. So GBI looked at something and said, in order for us to do a meaningful testing state, you need to get us more things.
Yes.
What kind of things?
The comforter and the sheets that were during the alleged assault.
Okay, and were those things that you had?
Yes.
And those have been delivered to the GBI?
Yes, sir.
So they now have everything they said they need to do whatever they're gonna do?
Yes, sir.
Okay, and they're in the process of doing whatever they're gonna do. Okay, it's not that you need more things or anything from the defendant. You've given them what they say they need.
Correct, Your Honor.
Okay. Is there anything outstanding in discovery besides those final results from the GBI?
I don't anticipate that there are, Your Honor, but there may be some, I think everything has been turned over, but I think I've turned everything over. I don't anticipate any issues.
Okay, Ms. Rios, I know you don't know what you don't have, but in looking at the case file, anything that you feel like is missing just based on reading the report, there should be a statement from so-and-so or anything like that?
No, Your Honor.
Okay, and then there are results in theory coming from the GBI. What kind of time frame has the GBI given you, if any, Ms. Clark?
They said 90 days and I've asked for it to be expedited.
And it was 90 days from when you just asked, or from a week ago or a month ago?
It would be 90 days from, I guess, when we provided the additional stuff to them.
Right, which was when?
That was last week.
Okay. All right. But you've asked for expedited. Your experience with GBI accommodating a request for expedited is what?
When they have indicated a specific deadline, after they do the initial testing, they're able to provide the actual, like, the deadline for the testing.
Sort of like what happened in Wright.
Right.
Okay. Okay. Ms. Rios, what are your thoughts about this? The state is saying not ready. Could we recalendar this?
No objection.
Okay. Mr. Previon, you remain on bond. You've been on bond for a long time. Let me just revisit. Your bond. You still wearing an ankle monitor?
That we.
We took it off?
Yes.
Okay, you didn't decide to stop wearing. There was an order that said you could stop wearing.
He never had it, and then we did an order when we realized he never had it to take it off. To remove that condition. Yes.
Got it. Okay. Wonder why the judge was very clear, different judge, that he was supposed to have one, but he never did. Okay. All right. Mr. Previon, do you have any questions? All right. Then we will see you next time this gets on the trial calendar. Mr. Ware, is Mr. Ware here yet? I'm sorry, what? Two people spoke. He is here or he is not? He's here. Okay. And how about Mr. Stewart? Okay. I'd actually like to start with Mr. Stewart. Mr. Brown, way back when, you expressed some concerns about Mr. Stewart and said maybe he ought to talk with some medical professionals. And I don't know that you've advanced that at all. And I'm a little leery of extending that. You and I aren't the medical professionals. And so our sense that Mr. Stewart might be working through some things isn't necessarily dispositive. And we're stuck. I'm not a big fan of severing because one piece is moving more slowly than another. So tell me what steps you've taken and what you see as the likely, what's happening next for Mr. Stewart.
Can we approach?
We can. Sure, please. Good morning.
Okay, that's I just saw it on here. Oh god. Take this one. Please?
That's only a typo.
Okay, I figured they just
They
did.
have everything they need.
Okay, that's included. Yeah, okay, she's gonna talk to him. Yeah, I know, that's what I'm showing you, like, excuse me. Yeah.
Yeah. Megan, do you know if trafficking is the 10-year?
You just have to improve it.
Yeah.
Sounds like he's following through and passing all the documents. She just made the documents. Always. Maybe the new cars. Yeah, because if they say they're going to go in 3 weeks or a lot of times change. That makes for a situation.
And the maximum.
In the hospital, and take the oxygen. Anything else on that? Okay, that's all that you got on the. You got on the discovery, it's just getting this.
I'll talk to him. I'm here.
Thank you. He's gonna do it until we do get a good car.
For sure. I'll talk to him. No, he called. I just I was just back when. So, yeah.
All right, so going back to.
Ware and Stewart, Ms. Gordon, my understanding is that you are ready to go forward, whether they're tried together or not, and you're not particularly interested in having this delayed excessively in an effort to have the defendants tried together.
That's accurate, Judge.
Okay. Mr. Brown, you are otherwise ready, but we need to work through the process you've initiated on behalf of your client, Mr. Stewart.
That's correct.
All right. And Mr. Abadi, are there any outstanding, we don't have this from the GBI or it's the holding pattern right now is dictated by sorting out Mr. Stewart's situation.
That's correct.
Okay. All right. So my thought is we see what magic Ms. Singleton can do. She's at least going to get an answer. And if that time frame is outside my comfort level, I'm certain it's going to be outside your comfort level, and you should weigh in on that. But if it's outside mine, then it may be that this has to be tried twice. But let's let Ms. Singleton plug in and see where we get with that. And it sounds like we'll hear something in the next few days. Anything else, Mr. Brown, on behalf of Mr. Stewart?
No,
He's here. Do you need to talk with him?
yes, I'll be happy to talk.
Okay. All right. Anything else on behalf of Mr. Ware, Ms. Gordon? Okay. He's here. Do you want to talk with him before? All right. So if we keep both of them up, we're almost through the calendar, and then folks can have conversations. Oh, and let me say this. I'm happy to engage with either of the defendants saying, generally, I won't go into specifics, here's what's going on. If they tell you, why am I here again? I'm happy to talk to them as well. Okay?
I wouldn't be opposed to my client coming out.
I'm not, I know you're not opposed to it. Talk with your client and then make that decision. And if you think it would be helpful for your client to have me say, here's what's going on, great. But I only offer that up. I don't require it.
Yes.
Okay? Thank you.
Thank you.
All right, Alonzo Miller.
Judge, I'm gonna step in and I'm gonna talk to him, so if we could hold this one, please.
Mr. Miller is in custody?
Yes.
Oh, okay. You're gonna talk with Mr. Miller.
Yes.
Your case, you're ready to go?
Yep, we're ready, Judge. I would prefer the second week for witness availability, but we'll be ready regardless. I think this should only be about 3 days.
Yeah, is that a Hiles estimate?
No, I think it's a fair estimate.
All right, and Mr. Miller, if it goes to trial, will take advantage of a lawyer?
Someone, hopefully.
Okay.
I'll be a lawyer.
Okay, I mean, he is not planning on doing it himself.
We will have an update after.
Okay, all right,
And
okay.
Judge, if I could just, well, is this the last case on the calendar?
There's one more, 2 defendants, and then that's it. So we can talk.
We could just approach after you call the calendar with the fence. I just, if it's one scheduling matter, I'd rather just talk.
Sure. That's fine. Let's just get through because we're now to the supplemental, which is co-defendants, Mr. Gallardo, who's in custody, represented by Ms. Rios.
That's one of the pleas.
Excellent. If that plea goes through, Ms. Cabrera represents Mr. Romero Silva. Should we do the Gallardo plea first, and then, or does that not change anything that you and Ms. Cabrera might be talking about?
We can we approach?
Well, how about this? That's the end of the calendar. So yes, you can approach. Is there anyone here who thought they had a case today and they didn't hear their case called? All right, we're good.
Good morning, Judge. I don't mean to interrupt, but Dexter McGraw.
Yep, he's here. I called him and I learned that you'd be zooming in. So just sit tight for a sec.
Yes, sir.
All right.
Will the Spanish interpreter will be needed, Your Honor?
That's what I'm about to find out. So don't leave.
Okay.
Aaron. Hey, good morning. How are you? It won't connect. You can see there's an issue there? Okay, I just want to make sure you knew what the issue was. That's all. Great. Thank you for being here. All right, so no one's here on some other case. And any word, Ms. Merkey, on Ms. Brown?
No, sir, I'm waiting on her to call back, or that's her station, and I called her, but.
Okay, we've similarly not had any success. We're trying, if she's stuck in court, it's not like she can answer her phone.
I must have missed this earlier. Ms. Brown is in Troop County? Troop County?
Yep.
first. And so, oh, did you already know that?
Well, her client said something about Troop County. But maybe she would be able to step out and join the Zoom. We'll see. You're gonna need to sit tight a little longer till we can maybe establish some contact to see if she says, oh, I'll be here this afternoon, or I can hop on the Zoom.
I'm sure, she texted me back this morning, earlier before court started, I let her know I was here, and she texted me back, so I'm sure as soon as she gets a chance.
She'll plug in. Okay, good. All right. So we're waiting on Mr. Adams. And let's talk with Mr. Schnipper. Mr. McGriff is here. You still here, Mr. McGriff? Right there. Okay. So Ms. Clark, where'd Ms. Clark go?
Oh, she stepped out for a moment.
Okay. Okay. Mr. Schnipper, Ms. Clark shared with me that because of the recent search warrant that was served, there's something still going on over at the GBI, and she was asking for a reset. Do you have any opposition to that?
No, sir. I've been with constant communication with Ms. Clark, and we're on the same page. I'm actually going to meet with her in a couple weeks to see if we can potentially resolve it, but defendant did adhere to the search warrant last Wednesday, and the investigators told me it may take up to 90 days of the GPIs. So I agree with Ms. Clark.
Okay, I'm interested in it taking less time than 90 days, but also glad to hear that the two of you will be talking soon, and we'll see what we can do. But it doesn't sound like this is one that we'll reach on this trial calendar. I just don't want to put it on another trial calendar so soon that we just look at each other again and say, well, we don't have what we need from the GBI. So we'll keep in touch with Ms. Clark on that.
Yes,
Mr. McGriff, do you have any questions about anything?
No, sir.
Okay, all right. You remain on bond. Stay in touch with your lawyer, and Ms. Clark will be in touch with you about what you're hearing from the GBI in connection with the McGriff case. If you and Mr. Schnipper reach a point of a potential resolution, let's not wait until another trial calendar. Let's get everyone in here, okay?
Yes, Your Honor.
All right, thank you. Thank you for dialing in,
Yes,
Mr.
sir.
Schnipper.
Thank you, Judge. Have a good day.
You too. All right, Mr. Adams is here. Good morning, Mr. Adams. I'm gonna have you talk with Ms. Nix about what we're gonna do with Mr. Walls. I'm gonna take a quick break so lawyers can talk and whatnot. Was there something you were about to say? What? Oh, right, it's Ms. Clark. I get that wrong. But you're gonna talk with Ms. Clark about Mr. Oh, good. Well, you're gonna keep talking. Maybe you're gonna talk with your client. When I get off the bench, that'll be easy to do. And I'll talk with Mr. Hiles. I'll talk with Ms. Cabrera. We'll see what's going to happen with some of these cases. Ms. Chavez, I'll let you know what's going to happen once I finish talking with Ms. Cabrera, okay? All right. Did you end up talking with your client, Mr. Brown?
I did, and he would like an update for the court.
Okay, I'll give him one when we're done with our quick break.
Thank you.
Thank you. All right, let's go to the jury room. I will mute things here.
How that happens. Okay. Yeah, nice. Easy. Perfect. Thank you. Oh, you're welcome. I'm gonna, you All right, court. That's all I ran down. It's a phone. $25, sir. 18.
Like. Okay. Still get super, isn't it? I gotta go to work. Stop it.
Is Ms. Wood back there? All right, well, we know where Ms. Rios is. We just need one of the two of them when we bring Mr. Miller out. We're going to bring Mr. Miller out in a minute. We're going to let Mr. Phillips say hello briefly, and then We'll go.
That's your name? More. Brush your teeth. You got your Crocs on. Look, I got the same shoes.
All right, Mr. Phillips, we will see you in about a week, okay?
My lawyer ain't called. My lawyer ain't called.
No, he was here.
The more I learn.
So hold on, Mr. Phillips, just so you know, Mr. Menettis, he had another court obligation, so he dialed in and we had a full discussion about how he's ready to go for the trial. It'll either start a week from Tuesday or the following Monday. And your family's gonna make sure clothing's brought down, same with Mr. Parks. So we're good to go, all right? All right, if you would bring Mr. Miller out, please. Ms. Merkey, someone, I don't know if it's Ms. Brown or her partner, law partner, will be here at 1 today, supposedly to take a plea. That's what I've heard. Ms. Nix, Ms. Brown or Ms. Brown's law partner will be here at 1 today for a plea in the Merkey case.
Okay, so be back at 1?
I'd be back a little before 1. Okay? Yes, this court 8D. Yep. Thank you. Mr. Miller.
How you doing? Good morning.
Good morning. I'm Judge McBurney. We've talked before. I just wanted to make sure I understood where you were and you understood what's coming up next. You are charged with a bunch of things. And given your criminal history, if you go to trial and you're found guilty of one or more of those things, the state has filed recidivist notice. And so I would be required by law to sentence you to the maximum, and it would be without parole. So I'm gonna have Mr. Hiles, who's the prosecutor in your case, let me know, number one, what the offer is right now. And number two, what the sentence is that you would face if you were found guilty. I don't know anything about the case. This may be the worst, as in bad evidence, case for the state ever, and you ought to go to trial. But if you and your lawyer have been talking about it and the state has some evidence, I just need to make sure you understand how large the dice are that you are rolling when you say, I'm not interested in whatever the state's offer is. But I don't know what it is. State's offer may be 100 years, and then of course you should go to trial. So I'm going to have Mr. Hiles tell me what the offer is, when it expires, and what you're looking at if trial doesn't go well for you. Then you can tell me, that's all fascinating. I already knew all that. I want to go to trial, or, okay, I need to talk with my lawyer a little bit more. Because this is it. If we don't sort it out today, then I'm going to get you in here on one of our 2 trial weeks. Mr. Hiles has told me his witnesses are ready. He's got about 10 of them, and they're going to move forward. So, Mr. Hiles, what is the offer today if Mr. Miller wanted to resolve this case short of trial?
Your Honor, the offer today is to plead guilty to 2 counts of aggravated assault and 3 counts of possession of a firearm by a convicted felon. The state would remove the recidivist punishment requirements. The offer is 25 years to serve 13 years, so he would be eligible for parole. Your Honor, he is facing, if convicted of all charges as alleged, 195 years. 185 of those would be, theoretically be run concurrent with each other. 10 of those years must be run consecutive to the other charges because they're possession of a firearm during the commission of a felony.
But if they were run concurrently with each other, we've got, for example, an aggravated assault, which is going to be 20 years to serve.
Yes.
What is the lowest number if I were to choose to run everything consecutively that I legally could? I understand a firearms offense must run.
Consecutively or concurrently?
I may have misspoken. If Mr. Miller goes to trial, he's found guilty of all counts, and I elect to run everything concurrently together, except those that legally I can't, what's the lowest sentence? You shared the maximum, which would be 195.
The lowest would be 25 years, but all of it, you must sentence to the max, and
Right.
it must be, the custodial portion must be served without the eligibility of parole.
Right. Okay. So it sort of a range between 25 and 195.
Yes.
If trial doesn't go well for Mr. Miller, obviously if it goes well, he's a free man unless he's wanted somewhere else. Your offer today is 13 to serve, but no recidivist notice, so he would be parole eligible. Unlike any sentence that's imposed after trial, because you intend to prove up the recidivist notice with certified copies of convictions.
Got the certified copies in hand. There are 5 of them, so all of them will apply to the possession of firearm by a convicted felon because of the number of them. I would add that regardless of what happens with the aggravated assault charges, I mean, if he goes to trial, one of the possession of a firearm by a convicted felon, he is on video under arrest with the large pistol being removed from his waistband.
Okay. Mr. Miller, you know better than anyone in the room what kind of evidence is out there and what isn't, what was on you, what wasn't. Do you understand what the state's offer is today? 25 to serve 13. 13 is a big number, but what's different today from what'll happen if you go to trial is that you have the possibility of parole for those 13 years. You understand that?
Yes, sir.
Okay. You understand that if you go to trial, the state will not be withdrawing. They'll be pursuing the recidivist notice. And that's not something a jury decides. They literally have to hand me certified copies of convictions. That's it. And so if they've got certified copies of your convictions, there's no argument from your lawyer or anything like that. They are what they are. I have to take judicial notice of them. And that sentencing requirement of sentencing you to the maximum and no possibility of parole, that kicks in just by operation of law. You understand that?
Yes, sir.
Okay. It sounds like you understand what's going on. Tell me if you've got any questions and what you want to do.
I'm gonna go to trial because I don't feel like I'm trying to get me a paid attorney like working on the day because my lawyer telling me one thing and every time I come back it's this and that and this and that. So I just got out for doing 15 years. My mom old, I know, so I don't know. I just done 15 years.
Okay.
Like I'm still being punished for my old charge. I haven't been in trouble since I've been out of prison.
So we don't need to get into any specifics. You heard what I heard, which is supposedly there's a video with you with a gun in your waistband. That's you getting in trouble. You're a convicted felon. You can't have a gun. A jury sees that. They're going to decide what they decide. Your lawyer is going to argue as best she can for you, whether you paid your lawyer or not. A video is a video. So what you need to be thinking through is how you manage that. It's your call, not mine. I just need to make sure you're going in eyes wide open and not feeling bad for yourself because you did some time and then you made some mistakes and are going to need to do more time. But you are entitled to a trial, and we will get you here either that first week I mentioned, which is 2 weeks from now, or the week after. I'm not slowing it down because you haven't hired a lawyer. There are two exceedingly experienced lawyers sitting at that table right there. They have your best interest in mind. You may not like what they have to say because they may be telling you the truth, which is this is not a great case for you. And if you go to trial, it's going to turn out less well than what this offer is. I don't know what'll happen at trial. Crazy things can happen. And jury may say, we got the wrong guy. But if the jury sees the kind of evidence that Mr. Hiles has described and they find you guilty, I'll be a little late to say, hey, can I go back to that 13 years with the possibility of parole? That ship will be over the horizon. But it sounds like you understand that, and you're focused on some other things that are important, like your mom's getting old and you've already spent some time, but you haven't spent some time, doesn't give you a pass this time around. Okay? Any questions about anything?
No, sir.
All right. Do you have family members who can get clothing for you to your lawyers so they can get it to Deputy Gordon so you're not dressed like that for trial?
Yes, sir.
Okay. As long as they've got the contact information for them, we'll need to get that kind of clothing here at the end of next week because you could be going to trial the week after.
Yes, sir.
All right. Thank you. Ms. Rios, you were in the room when Mr. Hiles explained that the second week probably is better for trying this case. Do you have a preference one way or the other? Okay. All right. Well, thank you, and thank you, Ms. Wood, for trying to get through to Mr. Miller. No one was going to do that today. Here's what's going to happen next. I got to step off the bench so Deputy Gordon can take some people down and bring Ms. Shanahan up. She's here. And then let's start taking some of those pleas. Okay? And this is the last call for Ms. Taylor. All right, so I'm going to enter a bench warrant for Ms. Taylor. Ms. Bennett, I heard you were having some second thoughts. Should I talk to you about trial as well, or are you going forward with the plea?
You don't need to talk to me about trial. I just feel violated. Actually, I feel very violated. I'm hurt right now. I'm in tears because I was wrong.
So here's the deal. I just need to know whether you're going forward with your plea or whether you're going to go to trial.
Can we have just about 15 minutes?
Yep. Let's make sure whatever plea we line up isn't yours at the beginning, so you can talk with Ms. Bennett so she can be thoughtful about, let her know I'm happy to hear from her when it is her turn during a plea colloquy to share her outrage, and that can be part of the process, but there's not a third option of the case goes away. All right. So we're going to do some inmate movement, and then I'll come out and take guidance from the lawyers as to what we're doing next. Mr. Brown, I think you're good to, oh, you wanted Mr. Stewart. Yeah, could you bring Mr. Stewart just to the door and then he can go down as well? Thank you for sticking around and standing up.
No problem. Thank you.
Yeah.
Mine's 3 to 2.
Literally when he's arrested. Hmm?
Good morning, Mr. Stewart. How are you? Good. I just want to give you an update on your case. I had you brought over today because I wasn't sure where we were in the process and if we could get this to trial, because of course the goal is to get you a day in court so that Mr. Brown can advocate on your behalf and see what a jury is going to do in the case. But Mr. Brown had taken some steps to make sure you had a chance to talk with a doctor. And I think we're about to make that happen. So I just wanted to make sure you knew that a doctor might be coming to see you fairly soon. I want to make sure you engage with that doctor and answer his or her questions as best you can. And then that'll help us figure out which way to move forward with your case. You got a co-defendant, Mr. Ware, and his case is ready to go. Ideally, you go to trial together. But we need to figure out what the doctor has to say first. So my request to you is, number one, remain patient, but number two, when that doctor does show up, that you engage with that doctor, okay? Does that make sense?
Yes, sir.
Any questions for me? All right, thank you. Mr. Brown, anything else?
No, thank you so much.
All right, thank you. All right, so Deputy Gordon will let me know when we've done the inmate switch. It's the only new person coming up is Shanahan. I think I'm saying the right name. Yes, and we'll start taking pleas, and you talk amongst yourselves as to the order in which we do that. Okay? Thanks. Yes, sir.
Thank you. Have a good day.
Where is, yeah, hold on one sec. Is Ms. Wood back there?
Yes.
Can you just have her pop to the door? Mr. McGillicuddy is still here. Were you going to talk to him and haven't had a chance yet, or you did?
I spoke to him and he wanted to wait and see what's happening.
Okay, got it.
So can I, come back up one?
Yes, be back a little before 1 o'clock. All right. And I'll be back in just a few minutes. So you're going to rotate the inmates around. Bye-bye.
Anything? Okay, I'm gonna run downstairs.
Okay, like the shoes go. Thank you. Very cute.
Do you want to leave? Yeah, this is it. Yeah.
She said no. Okay.
Is it just because he's spent so much time in jail?
Oh, that's right. But you're not even here. I said it'd just be easier to come over and just tell that it was a charge.
Have you seen the videos? The videos, that's fine.
Okay. I don't want to take out. And the one county possession of firearms, drug conditional felony. Next week we're 106 because that's 5.
Yeah.
Right, that's all we have to take out. All right, and, he's basically, because the main, these are when so it's
All right. No, this is where, yeah, all my cases on the track, not all. Some of them.
What do you call
Charge.
Still waiting. Did not. Just, I'm not gonna worry about that. Yeah, just leave it. But don't forget to tell them, I'm gonna stay away.
Oh, what is?
Yeah. So what we do is, but, yeah, some of them choose magic because of interest. Well, I'll ask him, I'll go over and take him to my parents, as we should hear it, it's really up to them. Right. And I don't even know how long. Right. What else do you have? Right. So I'm ready to do the. Yes. Who knows? I'm Miss Nelson. Hey, everybody. How's it going? Good. How are you? This is awesome. This is what's the. I have 3 pleas. Gallardo and. John Gallardo, and we have 3 for one. Yeah. Yes. Yes. They haven't brought her up yet, so I'm waiting to get back there to see her. They were swapping people out. And Jernigan is a plea attorney for number 10. Okay. And then I'm still waiting to see what number 13, McGillicuddy is doing. He's got the code and it's coming back at 1, so he's on. Okay. Yes.
Wow, Ms. Nelson is out here. It's really official. I know we can't start yet, but what are we going to start with?
first?
We sure can. But hold on, Ms. Bennett, we need to wait for the deputy to get back up and then we'll handle your situation first. Thank you. Oh, and I never oh my gosh. Ms. Chavez, I forgot to tell you, we're all set. I feel terrible, but when we had that meeting, it was cleared up about Mr. Romero Silva and my mistake in not letting you know too many things I was juggling. Thank you so much. Didn't mean to keep you tied up. Have a great day.
Thank you.
Glad I remembered that. Mr. Wooten, if you're going to be handling the plea, the way we usually do it is we get the prosecutor up here. So why don't you get situated? And then as soon as Deputy Gordon pokes his head out, we'll get Ms. Bennett up here along with Ms. Rios and get moving along. Mr. Adams, is Mr. Walls going to be a plea?
Yeah, we're trying to get it set up and signed up.
Okay. Your forecast is that it is a plea?
Well, I'm thinking a little bit.
Okay, great. I just want to fit in what we can this morning. I have a hard stop at 12:15 for our monthly bench meeting. Most fun of the month.
You're excited.
It's like those every 5-year doctor's appointments.
Pull out the eyelash type meeting.
Mr. Abate, Mr. Rowe, I know chatted real briefly with his client, and then came to chat with you. Any development there? Or just he was saying, hey?
There's I think a new development. He's finally heard the previous development, the previous lawyer, so he's gonna communicate more, it's fine. Now, Mr. Minetta's, his offer was a dismissal, so that's.
Meaning his counter offer, or he said that's what we'll take? Okay. That's a gap. Okay. Hey, you get stuck?
Something like that.
All right, something like that. I don't want to know. Okay, let's move forward. Ms. Bennett, if you would please come up with Ms. Rios. And let me make sure I haven't said good morning to Ms. Hawkins. Good morning, Ms. Hawkins.
Good morning.
You ready to go?
I am.
Excellent. And if you don't mind moving the screen a little so you're on it, so the court reporter can see you. And let me get the podium. There we go. That's who the court reporter needs to see. Okay, let's get on the record, please. This is, find the case again, position 12 on our trial calendar, State versus Shiloh Bennett, 23 SC 189690. Ms. Bennett is here in court with her lawyer, Ms. Rios. Mr. Wooten is handling this case for the district attorney's office. And in a moment, Ms. Bennett, Mr. Wooten's going to put you under oath. Once you're under oath, he's going to ask you a bunch of questions about this case and your rights. You need to answer them truthfully. You also need to let me or Ms. Rios know if you've got any questions of your own. Will you do that? Okay. What's going to happen in terms of process is Mr. Wooten will ask you a bunch of questions. He's going to share with me what he thinks the evidence is in the case. I'm going to ask a little bit about your background from someone who's on the Zoom. And then Ms. Rios is going to have a chance to speak on your behalf. And then finally, I'll give you a chance to say anything you want to say. So you will have an opportunity to express your frustration or whatever it is you're feeling about the situation. And maybe it's you're expressing regret, who knows? But you'll have a chance if you want to. You don't have to say anything at all unless you've got a question, because I need to know about that. But if there's a statement you want to make, I want to assure you, you'll be given a chance to do that, okay?
Yes.
All right, Mr. Wooten.
Excuse me.
Raise your hand.
I'm gonna
Hold on.
before we start. She's gonna have to talk up because she's barely audible.
Okay, so when you are answering questions, Ms. Bennett, use your outside voice, all right? I was able to hear you back there when you were telling me how you were feeling. You don't need to yell, but I do need you to speak up so the court reporter can hear you. Okay? All right, Mr. Wooten.
All right, could you raise your right hand for me, please? Do you solemnly swear or affirm that the testimony that you'll give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
And could you state your full, correct, and legal name for the record, please?
Yes, Shiloh Raina Bennett. I do have identification if you want it.
Okay.
The license is in the back.
Ms. Bennett, are you at this time taking or are you under the influence of any alcohol, drugs, or medicine?
No.
Is there any medicine that you normally take that you haven't taken today?
Yes.
Does that have any effect on your ability to understand what's going on in court this morning?
No, it does not.
How old are you and how far did you go in school?
16 years. That means I have a bachelor's and partially.
How old are you?
I'm 56.
Okay. And are you able to read, write, and understand the English language?
I am.
Do you understand that you're charged with, this is not what you're pleading guilty to, but what you're charged with in the indictment is in count 1, theft by taking over 5,000, in count 2, theft by taking over 5,000, count 3, theft by taking over 25,000, and in counts 4, 5, and 6, theft by taking over 5,000. Do you understand that that's what the charges are in the indictment?
No, I didn't.
Those are the charges, not what you're pleading to. Those
Oh,
are the
well,
original
can I
charges.
ask you the original charges?
Those are the original charges. That's the indictment that you've had all along. That's the language in the indictment. And Mr. Wooten is letting you know that's what you were charged with. And he's about to say, but because of negotiations through you and your lawyer, you're going forward on whatever he's about to say.
Oh, okay. I'm sorry. I really misunderstood you. So you broke down the 40,000. Thank you.
So that's each of those 6 counts in the indictment. And each of those, do you understand that pursuant to the negotiation, those are all going to be converted to misdemeanors?
Yes, I do.
Okay. Do you understand that you have the right to plead either guilty or not guilty? And I understand you're entering a plea of guilty under Alford, which means you're not admitting guilt, but that you believe it's in your best interest to proceed. You have the right to enter any of those pleas. And if you plead not guilty or if you remain silent, then you would go to trial.
Yes.
Have you had enough time to speak with your attorney, Ms. Rios, about all of the facts in the case, the circumstances known to you regarding the charges in the indictment and including any defenses that you might have?
I have.
Do you need any more time to discuss the case with your lawyer?
I don't think I need any more.
And are you satisfied with her services?
I am.
Do you waive any and all defects in the indictment?
I'm unaware of any defects, but we do wait for the purposes of the plea.
Thank you. And Judge, also for the record, the state is not aware of any outstanding warrants in the case for Ms. Bennett. And again, Ms. Bennett, just talking about what the original charges are, not what you're pleading guilty to today, but originally the charges carry the following sentence ranges. I want to make sure you understand that, okay? So as to count 1, the original charge, theft over 5,000, carries 1 to 10 years. Count 2, theft over 5,000 is also 1 to 10 years. Count 3, theft over 25,000 is 2 to 25 years. And counts 4, 5, and 6, which are also theft over 5,000, those carry 1 to 10 years. That's just what they carry if you were to go to trial and if you were convicted at trial. Do you understand that?
Yes.
And do you understand that this is a negotiated plea, which means that the state will recommend to the court the following sentence: that each of those counts be reduced to misdemeanor theft by taking, that the sentence is to be 12 months probation on each count, all of those counts to run consecutive for an effective sentence of 72 months on probation, but that probation will terminate once you complete all the special conditions of probation, which are that you pay $40,000 in restitution to Princess Caceres, Caceres, that you complete 80 hours of community service, that you complete an anti-theft class, have no contact with and stay away from Princess Caceres, that you must not conduct any financial transactions on behalf of another person without express written permission from the other person and approval from probation, that you must not serve as an accountant, bookkeeper, fiduciary, or holder or manager of funds for any other person, organization, business, group, or other entity in any capacity without express written permission from the other person, organization, business, group, or other entity, and with approval from probation, that you must provide an annual financial disclosure statement to probation each year by January 10th, that the first is due within 30 days of sentencing, but once restitution is paid in full, you don't have to do that anymore. And also that you must timely submit any and all personal and business tax returns and provide a complete copy of each of those to probation by April 25th of each year. Again, once the restitution is paid, you don't have to do that. Do you understand that that's what the state's recommendation is?
I understand that that's what the state's recommendation is, but may I ask you a question, please?
I suggest you ask your attorney before you ask me.
Okay. Maybe I can ask Judge McBurney. It's just the fact
The thing that you want to file against her.
right.
That member we said asked about that later. It says has
Okay.
nothing to do with this. We may proceed.
Okay, thank you. Do you also understand that the court does not have to accept that recommendation? And the court could sentence you to the maximum on the charges, but that if the court did that, you'd have the ability to withdraw your plea.
Yes.
Do you understand that this plea could be used to enhance sentencing on other convictions in this jurisdiction, as well as in other jurisdictions, including in federal court?
Yes.
Are you currently on probation or parole?
No.
And do you understand that as a result of being placed on probation in this sentence, if the judge accepts the negotiated agreement, that you cannot violate any criminal laws of any governmental unit or violate any of the special conditions of your probation, or you could be subject to revocation for the balance of the sentence?
Yes.
And are you a United States citizen?
Yes.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea, just as there would be from a conviction following trial?
Now I would like to know what those are.
So because it's being reduced from a felony, typically in a felony case, what I would say is you may lose your right to vote, your right to possess a gun, hold public office, passport, et cetera. This is not a felony case, so there's not any specific consequences, as a matter of law, but there may just be others, for example, if someone runs a background check.
I'll give you another example. Let's say, this is all pretend, but let's say 2 years from now, you get sideways with someone else because of a financial situation and charges are brought against you. The prosecutor in that case could look to this situation to say, look, Ms. Bennett did something like that before, and that is not a good development for you. So that's the point that Mr. Wooten is making. If you're not going to get mixed up in whatever this situation was, again, you don't really have a lot to worry about. And misdemeanors are very different from felonies. But it is true for anyone who pleads guilty to a case, even under Alford, that someone in the future could say, oh, you say this, but what about that situation in the past? Does that make sense?
It makes sense.
Okay.
And do you understand that by entering this plea today, you're waiving any and all defenses, including any mental health defenses?
I am.
Do you understand that if you went to trial, that you would have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify yourself or remain silent and not incriminate yourself?
Yes.
And now I'm going to go through a list of other rights that you're giving up, and at the end, I'll ask you if you understand that you're giving up those rights. Those include the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront the witnesses called against you, the right to have the assistance of counsel hired by you or a court-appointed attorney at that trial, the right to have the presumption of innocence, the right to testify on your own behalf and present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if you're convicted at trial. Do you understand by entering your plea today, you're giving up each of those rights?
Yes.
Has anyone forced, threatened, or promised you anything other than the agreed negotiation to get you to enter this guilty plea today?
No.
I'm sorry, I didn't hear you.
No.
And is it your decision to waive these rights and enter a guilty plea under Alford versus North Carolina because you've decided that it's in your best interest to do so?
Yes.
And are you aware that even if you do not admit guilt, that this still will count as a plea of guilty and places you in the same position as if you were convicted at trial by jury?
Yes.
How do you plead to the charges of 6 counts of the reduced charge of misdemeanor theft by taking in indictment number 23 SC 189690?
Guilty under Alford.
And is your plea freely and voluntarily given with full knowledge of the charges against you?
Sure, yes.
Do you understand that you may have only a limited right to appeal this guilty plea under Alford?
Yes,
And do you understand that because these are misdemeanors, that you have 12 months from today to file a habeas corpus petition challenging the voluntariness of the plea?
yes,
Your Honor, if this case had proceeded to trial, the state believes that the proof would have shown that beginning on or around June 18th, 2020, the defendant entered into a business relationship with the victim, Princess Caceres, in which the victim was supposed to purchase several businesses from the defendant. The victim was led to believe that those businesses had value because they would obtain funding through government grant programs, and she believed that those businesses would become profitable. The victim made 6 payments, which correspond to the 6 charges in the indictment, to the defendant, including on June 18th, 2020, June 22nd, June 29th, July 13th, August 25th, and September 16th, 2020, via wire transfers, checks, or online bank transfers. After the victim made those payments, she determined that she had been provided with some false documents related to those companies that she had purchased, and that they actually had no value, and that they were not approved for any of the government grant programs that she was led to believe that they were approved for. All these thefts occurred in Fulton County, Georgia.
Now, Ms. Caceres is something about Florida in this case. She's now in Florida?
She's living in Florida.
Okay, got it.
We have provided to Ms. Nelson the address for.
Got all that, and that doesn't need to go on the record so much as probation's gonna need to have that information as they forward the funds along. Okay, got it. Anything else?
No, Judge.
Thank you so much.
okay.
No, if you've got a question, I'm gonna now ask someone a little bit more about you, and then I was gonna turn to Ms. Rios. Do you want to hold the question, or do you want to ask Ms. Rios?
No, I can hold it until you.
Okay, all right. Good morning, Ms. Jackson. How are you doing?
Good morning, Your Honor. How are you?
I'm all right. Do you have any criminal history information for Ms. Bennett?
Yes, Your Honor. She has 59 cycles. The last arrest was November the 30th, 2021 in Gwinnett County for a probation violation. She does have prior felony convictions. One in 2016 out of Florida for fraud/swindle. One in 2010 out of Gwinnett County for forgery in the 2nd degree. One in 2009, it was a federal conviction with the Secret Service for fraud. One in 2007 out of Florida for 2 counts of fraud. One in 2005 for forgery in the 2nd degree. One in 2003 out of Florida for fraud. One in 2000 out of Gwinnett County for deposit account fraud, 2 counts. And she does have misdemeanor convictions.
I appreciate that. I don't need, you've shared more than enough. Thank you so much.
Yes, sir.
So before I hear from Ms. Rios, walk me through why a misdemeanor disposition for someone with multiple, I lie, I cheat, I steal convictions, that'd be Ms. Bennett, is getting misdemeanors in this case.
Yes, Judge. Really the biggest thing comes down to the evidence in the case. In a typical white collar case, we would have documentation of all the agreements, what the terms and conditions of any, purchase agreement or whatever it may be is. In this case, we don't have that written documentation. So it largely depends on testimony. And so we believe that after we evaluated all of that information, that this was the appropriate disposition. And the victim is aware of it and she's okay with it.
Okay, she's focused on getting some of her money back.
Yes.
All right, but she wasn't able to provide you or law enforcement with, here's the partnership agreement or this or that, where there'd be signatures and the type of documentation that a jury would expect in a white collar case.
That's exactly right, Judge.
All right, Ms. Rios.
Yes, Your Honor. I do understand Ms. Bennett's history when it comes to this case, and that's why she's so upset. It seems like they had a different understanding of what was the agreement. Obviously, nothing was written down. And so she had an expectation. She did provide services. It just wasn't up to, I guess, what the complaining witness thought that they should be, because she was giving her money different times. So she was getting something. It just wasn't what she thought it was, but that's why they should have been paperwork. Miss Bennett's 56 years old. She has her son here and her granddaughter. She takes care of her granddaughter. A lot of times when I call her, her granddaughter's in the background. So she is one of the primary caretakers of her granddaughter. She also is a minister. She just got ordained recently. And she also has a nonprofit organization that's helping people who are recidivists. It's called FAR Foundation to get housing. She understands how it can be hard to get housing when you have a conviction. So she's has started an organization to try to help people. So she's doing a lot of good work in the community. Despite her choices or her background in the past, she's doing good work today. And with that, that's what we think this is a good resolution to the case. She'll be able to provide and help the community and provide services to them and support her family and pay back some of the restitution money. She's just very emotional because she believes that in this situation, she didn't do anything wrong, which is why she's pleading under Alford. But we just ask that you accept the plea as negotiated.
Okay, give me 1 second, a little emergency here. All right, Ms. Bennett, I told you you'd have an opportunity to share anything you wanted to share. And I know you had a question that you tabled for a moment. If it's a question for me, you should ask me. And if there's anything you want to add, now is the time for you to do that.
Yes, I would like to add several facts to this case. Like I said, again, I'm pleading guilty. I take care of my granddaughter. I don't know what a jury of 12 would say or do. I have none of my information valid because it was stolen from me. I do have a police report out of Alpharetta in reference to this. So I have no phones. I have none of my computers or anything with the information where Ms. Caceres and I were doing business. Ms. Caceres acted as a third party involving in this business. Monies didn't come from her. She actually brought these people to me because I don't believe in LLCs. I believe in Incs and corporations. LLCs don't protect you. So she had provided PPP loans for these individuals. And as she did it that, she took 40%. She brought, my services are $6,500 per business. And what she did was she actually took the money from them and brought the money to me, sent the money to me. So that's why if you notice in there, it was $6,500, then some 13,000, but still to this day, there's about $10,000 that's owed to me. I'm okay with that. As long as you tell me that once I complete this and I'm off of probation, I am going to file, after I'm off probation, I don't have to ask your permission to do anything. I'm asking once this money is paid back, that I file a UCC because I want my money because I am out of money.
He can't do anything about it.
No, that's what I'm saying. He can't, I know he can't, but I'm telling the courts what I'm going to do afterwards.
Okay.
I am going to file a Uniform Commercial Code, a UCC 1 against her for my money back because everything that she provided was a lie. And I couldn't even believe that law enforcement took it. It don't even look right. As the prosecutor stated, there's no evidence. This should have been civil in reality. I apologize to the courts for wasting your time. Again, I'm never going to speak with Ms. Caceres. There's evidence where she asked me to put her niece, and I wanted her nephew, I want to be known, so it's no mess, her nephew on my business so that she can provide a loan for him. I did so. It's on the state of Georgia right now. I'm going to leave that alone. I want no communication with her, and I would hope that she never calls me because I will be contacting the courts. as that speaks, but I want to know why I have to have consecutive sentences of 1 year, 1 year, 1 year, 1 year, instead of a whole 4 years. My family is behind me 100%.
So I can answer the question. It is to give you the longest period of time to pay the restitution. As soon as you meet your requirements, you'll be in a position to petition me through Ms. Rios to have your probation ended. But it is through long experience that defense attorney, prosecutor, and judge have learned that if you have a real short time frame and a fairly sizable amount of restitution, someone just has to go slowly and say, hey, I'm having a little trouble this month, and all of a sudden probation's over and none of the restitution has been paid. My ability to enforce these conditions is limited to the period of probation. I think 72 months is an awfully long time, but it might be exactly the right time if, because of your financial circumstances, you have to pay restitution $20 a month. That in fact won't get you to $40,000 across those 6 years. But you'll pay as you are able. Probation works with your financial means and your family's financial means. But that's the 72. It's not meant to be punitive. It's to create the largest possible window without having a felony conviction. Not that that would change your criminal history all that much. And make sure there's that longest possible runway to get the restitution paid off. If you want to be done with probation, get your community service done, pay your restitution, and take that class.
What kind of community service? Because I'm 56 years old with heart conditions and multiple, so I need to know what those are.
You go through probation.
Yep, they are able to accommodate folks with work limitations. I'm not worried about that. They're not going to have you lifting heavy objects or running or anything like that. I'm sure you've got all sorts of things to share with them about what you can and can't do. All right. So, Ms. Bennett, I find there's a factual basis for your plea. It sounds like you and Ms. Caceres were a natural match. I also find that your plea is knowing and voluntary. Knowing means you've understood the things we've talked about. And voluntary means, while you're not excited about what's going on, you've decided that it is in your best interest to handle it this way rather than going to trial and run the risk that the jury hears about 1, 2, 3, 4, 5, 6, 7 fraud convictions as they're judging your credibility, which is what this would come down to. So I'll accept your plea. I will follow the joint recommendation. It will be 12 months for each of the 6 counts, which have been reduced to misdemeanors. Those will run consecutive to each other. But again, that's meant to give you the longest possible period to meet these obligations. The special conditions have already been put on the record. I agree with them. I'm not going to reread them, but the ones that, let me find that Ms. Nelson shared with me, is the $40,000 of restitution. You will be paying it to probation. You don't want any contact with Ms. Caceres. I don't want you to have any contact with her. She needs to leave you alone as well. I should add this. That condition's not meant to be a trap for you. If for whatever reason she's reaching out to you, let Ms. Rios know so she can let the prosecutor know and we'll deal with that. But don't write her back saying, I can't believe you defrauded me. You'll be paying your restitution to probation and they will get it to her. They will be letting me know how you're doing on restitution. And if we're 9 months in and you haven't paid a nickel, we're never hearing about that as to how it's possible that you've paid no restitution over 9 months. You'll also need to do the 80 hours of community service. As I heard Ms. Rios say to you, probation will work with you so that it is community service that both fits your physical limitations, but also your background, so that you aren't giving people financial advice or anything like that, because that's not a role for you, for folks who are looking for help. You'll take the anti-theft class, and then there are these limitations on what you could do professionally. I think they're appropriate given what I've heard about today.
Right.
Mr. Wooten, can someone from my office sign the indictment on your behalf?
Yes, Judge.
Ms. Rios?
Yes, sir.
And Ms. Bennett, is it okay if we electronically sign your name indicating an offered plea to the misdemeanors in this case?
As long as you put UCC 1308, meaning all rights reserved, yes.
Okay, I'll look into that. Anything else, Ms. Rios?
Yeah, thank you.
Mr. Wooten?
No, Judge, thanks.
All right, Ms. Bennett, you will be contacted either misdemeanor probation will contact you, or Ms. Rios is going to give you the way to contact them. Do you live in the metro Atlanta area?
Yes.
Okay, they're very local. They're about a block from here. It's important that you create that initial connection, because if a few weeks go by and they haven't heard from you or they've had trouble reaching you, then they're going to reach out to me saying, where's Ms. Bennett? And we start out in very much the wrong way. So if they're not calling you back, let Ms. Rios know, saying, hey, I've called them and I'm not getting a call back. You need to be very findable for them. But if they're not being responsive to your outreach, let Ms. Rios know and we'll fix that so you don't start out the wrong way with them.
Right, I will. And also, I just want the courts to know, I am 56 years old. I heard all those going back and forth. No one in this court know what my life has been through. You don't know how I got those charges, what was done, what was done. I pled guilty to those charges because that man right there was a baby. And I was married to a stockbroker. And I said I did do those things for the same reason I'm saying now. So him, his sister, and my other son wouldn't be without me, okay? Next thing I want to say is I love what I do. I love what I do, like playing golf. I love golf. And I love working. I love researching. And I have not done anything wrong in the case of Ms. Caceres, but like I said, I plead under the Alfred plea because I don't want my life taken away from that little girl, okay? And I don't want that little girl to go through anything. But what I do want to do is resume my business, because I do business in all 50 states. So I want to resume my business, and I will have my contracts looked over. I've already have them.
Right. You are free to be a business person. It needs to be on the up and up, and it'll need to be, if it involves any kind of financial transactions, that's the kind of thing that probation is going to need to not be reviewing from a business perspective, like, hey, that's a good investment idea or a bad one, but they need to make sure that we don't in a couple of years have 1, 2, 3, 4, 5, 6, 7, now 8, your 9th felony investigation. And you can blame it on your ex-husband.
I'm not blaming it on anyone. I'm just stating what the case was. It's not just my
ex-husband. The case is, okay, it's not one. It's the feds looking at you, and Gwinnett looking at you, and Florida looking at you.
No, Your Honor, you don't have the case in front of you. The Fed said Ms. Bennett had 1 identification. My ex-husband had 49, okay? So that's what it is. You have to read that case. My ex-husband got 10 years. The feds gave him those 10 years because they said, look at what he did to his poor wife, okay? So that's it. That's what I'm saying. None of those facts are in this courtroom right now.
They aren't.
They're not. So that's me, and I suffered from that. Nobody's taking the accountability that I suffered. That's the reason why I'm freaking now, and my son is trying to tell me, like, Mom, it's okay. It's not okay.
All right, Ms. Bennett, you've got some healing to do, and I think some self-accountability to do as well. Thank you. All right. Thank you, Mr. Wooten.
May I have an excuse?
Yes, I'm issuing a bench warrant in the other matter.
And
Okay.
do you want us to provide that to your office?
Yeah, if Ms. Nelson will coordinate with you. She just needed to know who the prosecutor was. It's you, and she'll coordinate how to get that bench warrant. Okay? Thank you so much. All right, what is next?
Jernigan is ready for it.
Great. Can we bring Mr. Jernigan out, please? Are you all still here for Mr. Parks? I don't. Oh, you're Miss Henderson, right? Okay. Can we do Miss Henderson's plea soon too?
That's fine. I'm happy to let her go first.
No, we don't have Ms. Rios right now. So let's do Mr. Jernigan, and then let's do Ms. Henderson.
This one shouldn't take too long, Judge.
Good. All right, Mr. Jernigan, you are position 10 on our trial calendar, 23 SC 189520. And Ms. Wood tells me you're ready to enter a plea. Is that correct?
Yes, sir.
Okay, when you're answering questions, and there'll be a bunch from Ms. Nix, who's seated to my left, you make sure you answer loudly. The court reporter is remote, so she's going to need to hear you through that microphone, all right?
Yeah.
Louder?
Sir.
Great. Okay, excellent. Ms. Nix, when you're ready.
Mr. Jernigan, please raise your right hand. Do you swear or affirm that any statements or testimony that you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Please state your true, correct, and legal name.
David Tremaine Jernigan.
Are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No, ma'am.
Is there a medication that you normally take that you have not taken or been given today?
No, ma'am.
How old are you?
23.
How far have you gone in school?
Graduate.
High school?
Yes, ma'am.
Graduate high school, okay. Is English your native or dominant language?
Yes, ma'am.
Do you understand that you've been charged with the following offenses: 2 counts of aggravated assault?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes, ma'am.
Do you understand that if you plead not guilty or remain silent and refuse to enter any plea at all, then the state is required to prove the charges against you at a jury trial?
Yes, ma'am.
Have you had the opportunity to review your rights with your attorney?
Yes, ma'am.
Have you had enough time to speak with your attorney about all of the charges in this indictment against you, including the facts and circumstances relating to each charge?
Yes, ma'am.
You need more time to discuss the case with your lawyer, Ms. Wood?
No, ma'am.
Are you satisfied with her services?
Yes, ma'am.
You're doing a great job with the volume, by the way.
Ms. Wood, do you waive a formal reading of the indictment for purposes of the plea?
So wait,
And do you waive any and all defects in the indictment for purposes of the plea?
we do.
Mr. Jernigan, do you remember having been arrested on these charges?
Yes, ma'am.
Has your attorney advised you of the minimum and maximum sentence for each charge to which you're pleading guilty today?
Yes, ma'am.
Do you understand that today you're entering a negotiated plea of guilty, which means that the state will recommend the following sentence to the court? State will reduce both charges to simple assault under OCGA 16-5-20 and recommend a sentence of 12 months probation, each to run consecutive with each other. So a total of 24 months misdemeanor probation. Special conditions are no contact with Carol Green or Javon Armelin, Jayvghon Armalin. Stay away from the incident location, 2737 Marco Drive Northwest. Complete 40 hours of community service and complete an anger management class. Do you understand that's the state's recommended sentence?
Yes, ma'am.
Do you understand that the court is not required to accept the state's recommended sentence? Do
Yes, ma'am.
you understand that the court has the right to sentence you to the maximum possible sentence on each charge?
Yes, ma'am.
You understand that since there are multiple charges to which you're pleading guilty today, the court also has the right to run those sentences consecutively?
Yes, ma'am.
You understand that if the court decides to order a sentence that differs from the negotiated plea you are expecting today, you do not have the right to withdraw your plea of guilty?
Yes, ma'am.
Are you currently on probation or parole anywhere?
No, ma'am.
You understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit?
Yes, ma'am.
Do you understand that if you're on probation, you must follow all the special conditions of your probation?
Yes, ma'am.
Do you understand that if you fail to follow all the special conditions of your probation, then you'll be subject to revocation of that probation for the balance of your sentence?
Yes, ma'am.
You understand that you are not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
You understand that by entering a plea of guilty today, you are waiving any and all defenses, including any mental health defenses?
Yes, ma'am.
You understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, to remain silent, to confront witnesses against you, to the assistance of counsel, to the presumption of innocence, and the right to appeal if convicted of these charges at trial.
Yes, ma'am.
Is it your decision to waive these rights and enter a guilty plea today?
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
Is it your decision to enter a guilty plea because you are in fact guilty?
Yes, ma'am.
How do you plead to the charges of 2 counts of simple assault in indictment number 23 SC 189520? Guilty.
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
You understand that you have only a limited right to appeal this guilty plea conviction.
Yes, ma'am.
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition?
Yes, ma'am.
You understand that since these are misdemeanors, you have only 12 months from today to do so?
Yes, ma'am.
Judge, had this case gone to trial, the state would expect the evidence to show that on or about June 25th of 2021, the defendant did attempt to commit a violent injury on the person of Carol Green and Javon Armelin at 2737 Marco Drive Northwest, which is in Fulton County. Nothing further from the state.
Okay. Little more context. Was it car against car or was it car against pedestrian?
Car against pedestrian.
Okay, got it. And stranger against stranger?
I believe that Mr. Armelin and the defendant knew each other, and Miss Green is Mr. Armelin's grandmother.
Grandmother?
Yes.
Okay, no one got hurt?
Not
No one got seriously hurt?
seriously.
Okay, and you've spoken with either of the victims about this?
We
Or
have-
someone from your office has?
We have
Tried to?
tried to.
Okay, got it. Ms. Jackson, any criminal history information on Mr. Jernigan?
He has 4 cycles. The last arrest was May the 31st, 2023 in Macon County, Georgia, for possession of marijuana, a misdemeanor. There was no disposition for that arrest. He does appear to have an outstanding hold out of Marietta, Georgia, for a family offense. The date on that warrant is March the 19th, 2024. There are no convictions listed in the GCIC. Nothing in addition, Your Honor.
Thank you. Ms. Wood, is that hold news to you or you and Mr. Jernigan know that's his next stop?
Yes, and he's actually already housed at Cobb, so hopefully it'll be
Convenient.
swift transition, Judge. He is 23 years old. He's a high school graduate. He has family and support. His sister is present in court. He's been in custody since July 28th, so 40 days. He was working at Popeyes prior to his arrest. We are eager to get this behind him and get him to Cobb to resolve that matter. So we ask that you accept the state's recommendation.
And the situation in Cobb, I didn't understand, when we obviously get into the facts of it, but a family matter, it's a criminal charge or it's some kind of, you're behind in child support and so we're holding you, or?
I think it might be a family violence, maybe a battery or it's something, but it's
Okay.
yes.
But he knows about it and
Yes.
he'll deal with it.
Yes.
Okay. Mr. Jernigan, anything you want to add?
No.
No? Okay. You understand that if I follow the recommendation, which I intend to do, you don't get out today. You've got to sort out whatever's going on in Marietta.
Yes.
Okay. All right. Well, I find there's a factual basis to your plea that, 3 years ago, a little bit more, you and Mr. Armelin got into it in some way and people got concerned and the police were called, et cetera. I also find that your plea is knowing and voluntary. Knowing means you've understood all the things we talked about. You have questions about anything?
Yes, I would say, where do I do the community service at?
Great question. You and probation will talk about that, and they will empower you to find a place if you know, hey, I like doing that at the YMCA or wherever. As long as it's legit, it's not your own business. You're like, hey, what I'm doing is running my own business, but it's actually community service. You can pick it. It just has to be verifiable. So it's not a note from your sister saying, yeah, he washed my car 10 times. But if you don't, if you're passive about it, then they'll find something. And that's when you see poor guys picking up trash on the side of the road. It doesn't have to be that if you are proactive about it.
All right.
Any other questions?
No, that's it.
Okay. All right. I also find that your plea is voluntary, meaning no one's forcing you to do this. I'm going to sentence you on count 1, which has been reduced to simple assault, to 12 months to serve 1 month with a balance on probation. You'll get credit for the time you've served. And count 2 is going to be 6 months probated consecutive. So it's a total of 18 months to do 1 month balance probated. So it's a little less probation than was discussed. Special condition number 1 is no contact with either Mr. Armelin or Ms. Green. So leave them alone. Stay away from that location where this situation happened. 40 hours of community service, anger management. And I will tell you, if after the first 11 months of your probation, you've done all these other things, then you can petition to have your probation terminated early. So if you're staying out of trouble, doing the right thing, this can go away a little bit early. Ms. Wood, anything else on behalf of Mr. Jernigan?
No, Your Honor, thank you.
Can my office sign the indictment on your behalf?
Yes, please.
Ms. Nix, anything else on behalf of the state?
Yes, sir.
Can my office sign on your behalf?
Yes.
Mr. Jernigan, we now electronically sign indictments. Is it okay if we sign your name indicating your plea to the 2 misdemeanors?
Yes, sir.
All right, we're done. You're going to get information about how to contact misdemeanor probation through Ms. Wood. So either you got to give her your sister's info or yours when you get out. But if they can't find you, they're just going to come to me with a warrant. All right?
All right.
Good luck.
I'll give it to her.
All right, Mr. Abate, can we do Ms. Henderson now? Great. Mr. Adams, is Mr. Walls going to be a plea?
It will be,
Okay, I just want to manage everyone's schedule. It depends on how long Ms. Henderson's plea takes, but it may be that we then have to break for lunch. And then we would take up the Walls plea at 1 when I get back. But I have my judges meeting. I actually sadly don't get to do lunch, but I got to get on that call. But let's see how quickly the Henderson plea goes. And then it just maybe we break a little early. But we will certainly do Mr. Walls when we get back from lunch.
okay, thank you.
Sure. Ms. Henderson, if you'll come on up and stand with Ms. Rios, please. Are you ready? Okay, this is position 2 on our trial calendar, State versus Carrie Henderson, 21 SC 180098. Ms. Henderson, Ms. Rios tells me you're prepared to enter a plea. Is that correct?
Yes, sir.
Okay, Mr. Abate is going to put you under oath and then ask you a bunch of the same questions you've heard other people answer. Some of them will be obviously specific to your case. You need to answer truthfully, and you need to let Ms. Rios know if you've got any questions of your own, okay?
Yes, sir.
All right, Mr. Abate.
Good morning, Ms. Henderson.
Good morning.
Raise your right hand. Do you solemnly swear and affirm the testimony about the matter in the court to be the truth, the whole truth, and nothing but the truth, ma'am?
Yes, sir.
Put your hand up. Could you please state your true, correct, and legal name for the record?
Carrie Octavia Henderson.
And Ms. Henderson, are you at this time taking or under the influence of any drugs, medicine, or alcohol?
No, sir.
Is there any medication that you take on a regular or daily basis that you have not taken today that would hinder or affect your ability to understand why you're here?
No, sir.
And how old are you, ma'am, and how far did you go to school?
The 11th grade, and I'm 44 years old.
And Ms. Henderson, are you able to read, write, and understand the English language?
Yes.
Okay. And do you understand that you're charged with the following offenses in indictment number 21 SC 180098, counts 7 and 8, count 7 being false statements, and count 8 being criminal solicitation to commit false statements?
Yes.
Okay. And do you understand, ma'am, that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty, remain silent, you may receive a jury trial.
Yes, sir.
Okay. And have you had an opportunity to speak with Ms. Rios about the rights you're waiving by taking this plea here today?
Yes, sir.
Okay. And have you had enough time to speak with Ms. Rios, or do you have any additional questions for her regarding the indictment, the facts of the case, or any potential offenses?
Yes, sir.
Do you have questions?
No, I don't have any questions.
And are you satisfied with the services that Ms. Rios provides?
Yes, I'm satisfied.
Ms. Rios, do you waive formal reading of the indictment?
Yes.
Do you waive any and all defects in the indictment, including any respect to your client's name for purposes of this plea?
I'm unaware of any defects, but I do wait for the purpose of the plea.
And Ms. Henderson, do you understand that the minimum number of years of penalty for count 7 false statements is 1 year, the maximum being 5 years?
Yes.
And do you understand that for count 8, the criminal solicitation to commit false statements, the minimum penalty is 1 year and the maximum being 3 years?
Yes, sir.
Okay. Do you have any questions about the minimum maximum sentences for each charge you're pleading guilty to?
No, sir.
Okay. And do you understand that this is a non-negotiated plea of guilty, which means that I would say make a recommendation to the court, and then your counsel, Ms. Rios, also have an opportunity to make a recommendation to the court. The court is not bound by either recommendation, can send it to you as he sees fit, and can send it to you consecutively or one after another for each one of the counts you're pleading guilty to.
Yes, sir.
You understand that if you are not a United States citizen, a guilty plea will affect your immigration status and will result in deportation, regardless of any advice given to you by your attorney or anyone else?
Yes, sir.
You understand that you waive any and all defenses by entering a plea of guilty here today?
Yes, sir.
You understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and to not incriminate yourself, the right to confront witnesses against you, the right to the assistance of court-appointed counsel if you are unable to afford an attorney at the trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and to compel the production of evidence, the right to have the charges against you proved beyond reasonable doubt by the state of Georgia, and the right to appeal if convicted of these charges after trial. You understand that you're waiving or giving up all of these rights by entering a guilty plea here today?
Yes, sir.
And Ms. Henderson, has anyone forced, threatened, or promised you anything to get you to enter a guilty plea here today?
No, sir.
Okay. And is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
Yes, sir.
Okay. And how do you plead to count 7 false statements in indictment number 21-C 180098?
Was it, I thought you had said 8 and 9 before. I may have misheard. It's 7 and 8?
Yes, Your Honor.
Okay.
Guilty. And then how do you plead to count 8 criminal solicitation to commit false statements?
Guilty.
And then is this guilty plea freely and voluntarily given with full knowledge of all the charges against you?
Yes.
And Ms. Henderson, do you understand that you may only have a limited right to appeal this guilty plea conviction?
Yes.
And lastly, do you understand that you have only 4 years from today for a felony charge to file what's called a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, sir.
Is that something you, at a prior time and today, you had an opportunity to speak to not only Ms. Rios, but Ms. Feely, who was your prior counsel?
7.
I never really spoke with Miss Feely. I always just been Miss Rios.
Okay. And Ms. Rios says satisfied with your questions as it relates to habeas corpus petition?
Yes.
Okay. Your Honor, had this case proceeded to trial, the state would have been able to prove beyond a reasonable doubt that on September 13th of 2021, around 6:30 p.m. In the Notting Hill neighborhood, specifically at 4226 Notting Hill Drive, Atlanta, Georgia, is in the Zone 4 area of Atlanta. Mr. Tobias, which is Tobius Arnold, was shot and killed. He was shot in the back of the neck and it exited out the front of his body at that location located here in Fulton County. As a result of that, police were dispatched to that area at home off Notting Hill Drive. And on September 13th, 2021, Ms. Henderson was interviewed by several members of the Atlanta Police Department, specifically Detective Churchill. And during her interview with Detective Churchill, Ms. Henderson spoke to Detective Churchill and told Detective Churchill that a white car located up the street 4 or 5 houses down at 4215, as it left the area of the driveway of that home, began to shoot out the white vehicle at and towards the direction of Ms. Henderson and the group of individuals that she was with. As Your Honor is aware of hearings related to co-defendants in this case, there is video surveillance footage from several different cameras, from several different angles. All of those cameras and all of those angles show definitively that there was no one shooting as the white car drove away. And in fact, the white car left 4215, traveled a few feet and took a left out of the neighborhood on County Line Road, and is never seen entering the neighborhood again until after the shooting, because their house, 4213, had been shot up, and they'd been called by the occupants or other residents of the home to come home because of the shooting.
Is the shooting that resulted in Mr. Arnold's death the same shooting up of that address you just mentioned, or they're two different events?
They are one event. They're two different events, but they're all related in the sense that the shooting began at 4226 Notting Hill Drive, and after the shooting began at that location, the defendants, the co-defendants, Mr. Parks and Mr. Phillips, ran up Notting Hill Drive and had passed 4213, where the white car previously was, well after it turned out of the neighborhood. And as it's running up, you can see on the video cameras and Mr. Parks and Mr. Phillips telling their unidentified, unindicted co-conspirator to make sure he had his face and pull his mask up, so the cameras can catch them shooting at the house as they ran by as well.
Got it.
She further mentioned to Detective Churchill that her son, Mr. Kamaraci, never pronounced his name correctly, so I apologize, but it's Kamorace Parks, was not at the location at the time of the shooting. All of the witnesses and the video evidence indicate otherwise. She further spoke with Detective Thorpe and reiterated these same points that she had made to Detective Churchill. Upon further investigation, as Detective Thorpe and Churchill and other assistant detectives spoke with the widow of Mr. Arnold, Ms. Onada, which is O-N-A-D-A-L, and speaking with her, and during the several interviews in which they spoke to her, she told them and indicated that Ms. Henderson, our neighbors, they live next door to each other, and Ms. Henderson, in the days following the death of her significant other, Mr. Arnold, continued to approach Ms. Nell and ask her and tell the detectives that her son, Mr. Parks, was nowhere near the shooting and murder scene of Mr. Arnold. To have this case proceed to trial, that's what the state was able to prove beyond a reasonable doubt. As it relates to Ms. Henderson's criminal history, she does have 17 cycles. She has no felony convictions. I say that in the sense that it looks like from re-reviewing her criminal history that she did on February 8th of 2006 in Clayton County take a first offender plea to an 8-count indictment, 1 count of financial harm, theft, and 7 counts of forgery in the first degree. She was sentenced to 3 years probation, or 2 years probation, excuse me, for that case. She successfully completed it. And from my review of the records, it looks as if that case was discharged under the First Offender Act on April 8th, 2008. So she's here before you, not convicted of. The state's recommendation is 5 years probation as to count 7, and then as to count 8, 2 years probation to run concurrent with count 7. And my recommendation is for that after 2 years, Ms. Henderson is not any violations of the law, that she go to non-reporting or suspended probation for the remaining 3 months.
Okay, and no special conditions?
Other than not to speak to any of the witnesses prior to the completion of the case.
Okay.
Which would include herself.
All right. Is it the state's theory that Mr. Arnold was an intended target, or that he was shot inadvertently in the midst of gunfire between people?
He was an unintended target, Your Honor. It's the state's theory that Mr. Parks and Phillips began shooting in a direction for, an unknown reason for the court. And while doing so, Mr. Arnold was in their purview of.
Line of fire. Okay, got it. All right. Ms. Jackson, Mr. Abadi provided a pretty thorough recitation of what he saw in the GCIC. Do you have anything in addition to that?
No, Your Honor.
All right, thank you. Don't mean to supplant you like that, but I appreciate it.
That's okay.
Ms. Rios.
Your Honor, I initially thought she had her first offender available. We talked about it. I wasn't aware that she had already used her first offender. I do need to explain that changes things a little bit, that she
Okay.
would have that available to her.
Well, let's make sure, it sounds like, I want to make sure we've got the right criminal history. Every once in a while, there are siblings who have similar names, et cetera. But what Mr. Abadi relayed to me was that back in '06, that was a minute ago, you had some case involving forgery and maybe stolen credit cards that you resolved, and it sounds like you used your first offender back then.
No, I was told that if I completed the probation with no problem, then it wouldn't show up. And
Okay,
what
that's
I
first
done.
offender. They may not have called it that, but when someone tells you, hey, if you do well on probation, it won't show up anymore. That's exactly what first offender is. And so one time, the person's first offense, they are given that opportunity that, you know what, you've done well for 30 years of your life, however old you were back then, 20 years of your life. And now, if you can do well on probation, we're going to call that was just a mistake, a blip in your life, and it won't show up. But you've done that. You don't get it. There's not a second offender. So you and Ms. Rios should chat a little bit, but you have already used your first offender, and you used it on whatever that case was way back when. Okay. Mr. Adams, you should feel free to go to lunch. We will not be able to get to Mr. Wall since he's got two cases. I know we won't get to it before I need to break for the judges meeting. So if you could be back here at 1 o'clock, please. All right. And I don't know who else is in court, but if you're here for a case other than Ms. Henderson's, you're free to go to lunch. We'll be resuming at 1.
Thank you, sir.
Do you have a preference between that first Tuesday or the second Monday? Ms. Wood, Ms. Shanahan, is still wanting a trial. Is that where we are?
She'd asked me to call her mother, so I just got, when I need to pop back there, and just square everything away, but as of right now, yes.
Okay. I'm just trying to figure out how we line up the different cases that need to be tried. It just fits better that way, because if we start on that Tuesday with hopefully just 2 defendants, we could still spill into the following week. If we start on that Monday, we should fit it all in that 1 week, and we would do Shanahan rather than when do we start Shanahan? Does it start on a Tuesday or a Wednesday of the second week?
Of the first week.
With Shanahan, we will be correct.
We're ready to proceed, Your Honor.
All right, Ms. Henderson, it sounds like this is a wrinkle you were not expecting. But I want to make sure you had enough time to consult with Ms. Rios as well as family members. I saw you meeting with a few folks.
Judge, I'm just ready to get this behind me. My parents is sick, and I'm like, I've been without a job ever since this because of the way that it's wrote up. It's murder. It's not showing up the 2 charges that he reading. It's showing up murder. So I'm just ready to get it behind me.
Okay, I appreciate that, and I can relate to that very much so, especially the parent situation. Does that mean you want to go forward, even though you've learned to your dismay that you're not eligible for first offender because you already used first offender?
Judge, I'm gonna go forward with it. I mean, you know, even back when I was coming, Ms. Feely, he told you that he was gonna dismiss the charges against me, and then he came back and said that's not what he wanted to do when you asked him what he wanted to do with me. So, I mean, it's just been a whole bunch of back and forth for almost 3 years. Next week will make 3 years.
It is a long and winding road for you, for your son and others. Here's where we are now, and the state is making the offer it's making now, and maybe not an offer it had made before, but I don't recall specifically what you're saying. I'm not saying it didn't happen. I've seen you and your son and the other defendant so many times, it's hard to recall. I am glad that we are finally getting closure for you right now, and then your son and his co-defendant will have an opportunity to let a jury decide what happened in the case, and that'll be not next week, but the week after or the week after that. So I'm hearing you say you want to go forward. And I think we reached the point, Ms. Rios, where you were going to share with me what you wanted to, if anything, about Ms. Henderson and her situation.
Yes, Your Honor. Ms. Henderson, she's 44 years old. Before all this happened, she was working at Jazz Warehouse. They closed down, and then since then they were understanding about the situation, but it's been hard for her to get a job with it showing. I'm not sure why it's showing up with the murder and not separated out. I'll look at see if there's anything I can do. Hopefully, with her taking a plea and it's just to those counts, maybe that will make a difference.
Sure, and if I need to get involved with an order to GCIC, I'm happy to do that, because while they're connected, it's the same case. People get charged with different things in cases all the time, but if what got entered was all the counts for each of the 3 defendants, that's out there. So we'll look at what we can do. And I'll hear from you in a minute, Ms. Henderson. Let's have Ms. Rios finish.
She takes care of both of her parents. They have congestive heart failure and some other serious illnesses, and so she's being their caretaker. The issue was initially she was trying to avoid a felony conviction because she's trying to get paid by the state at least to take care of her parents. She also has 4 children, 2 adopted children, and she's married, and she just wants to continue taking care of her family. She's been really stressed out with all the responsibilities and everything that's going on with her son. We're also asking the fees to be waived for a while since she isn't working. Minimum, I guess, maybe 6 months, so she can figure out what she needs to do to help provide for her parents and her children. What fees? The probation fees.
Okay. All right. Thank you. Ms. Henderson, is there anything you want to add to what Ms. Rios just shared about your situation?
No, sir.
Okay. Well, Ms. Henderson, I find there's a factual basis for your plea.
One second, Your Honor. I'm sorry. I know Mr. Abati was asking for it to be suspended after 2 years. I'm asking for it to be terminated after 2 years. That's the only difference.
Okay. I find there's a factual basis for your plea, and that your plea is knowing and voluntary, meaning you've understood what we talked about. And if you didn't, you had a conversation with your lawyer about it, and that while you are not enthusiastic about this, to use your words, you're ready for this to be over. And so this is the way you want to get it over with. Is that correct?
Yes, because I'm just running back and forth, spending money, trying to get back and forth down here. I'm already not working.
Okay. Well, I'm hopeful that you're going to be able to find work soon. So I find there's a factual basis. I'm sentencing you pursuant to the Probation Options Management Act. And all that means is that while you're on probation, if for any reason there's a small issue, and I hope there are no issues, but a small one, like you're not going to meetings, then you and probation will solve that. But if it's a big issue, and that would mean you get arrested for something, I don't see that happening to you at all. But if you did, that will come back to me on the probation side. Ms. Henderson, I'm going to sentence you to 5 years on count 1 and 2 years on count 2. I'll run those concurrently with each other. That means at the same time. The special condition of your probation is that as long as your son's trial
One second.
Also saying, after suspended this part, because she's been 3 years.
I'm good. Okay.
And one thing, Your Honor, she's pleading under Alfred. She's not admitting guilt. I should have said that earlier.
Okay. It's a plea under Alford. So it's a plea that you think is in your best interest. Is that right?
It is.
Okay. Your total sentence is the 5 years of probation. The special condition of probation is that you have no contact with any potential witness in your son's trial. That includes your son until the trial is over. I am setting what's called a behavioral incentive date at 18 months. And that means 18 months from today, if you have had no issues on probation, probation is free to reach out to me to say, Ms. Henderson has been a dream to work with. We think you should close her case out. And I'll tell you, if I get a request like that, I usually sign it because there are people who are not a dream to work with on probation that take up all of probation's time because they're being knuckleheads. So that is an incentive for you to, for the next 18 months, do it exactly the way you and probation agree to make it happen. And then that closes your case out. I will waive your probation supervision fees for the first 4 months while you figure out what you're going to do for employment, taking care of your parents, etc. Mr. Abate, anything else on behalf of the state?
No, Your Honor, no objection to your staff signing for the state.
You read my mind. Ms. Rios, anything else we need to cover?
No, Your Honor.
And can we sign on your behalf?
Yes, sir.
And Ms. Henderson, finally, you, any questions about anything I said about your sentence?
No.
Okay, and is it okay if we electronically sign your name indicating your offered plea to the 2 counts of the indictment that name you?
Yes, it's fine.
We can do that? Okay. I'm gonna need you to stay right there because we have Officer Evans from probation and she needs to give you reporting instructions. So I'm gonna have you talk with her and then you are free to go.
Thank you, Your Honor. Miss Henderson, what's your current address?
3450 Forest Park Road, Southeast Atlanta, Georgia, 30354, apartment 2307.
Forest Park, Atlanta, Georgia, 30354, apartment
2307.
Okay, and that is Fulton County?
Yes.
Okay, you're gonna report to 276 Memorial Drive. That's Southwest Atlanta, 30303 on September 15th, 2024 at 8:30 a.m. May I have a good contact number for you?
What day is
You said September 17th?
15th.
September 15th at 8:30?
Yes.
Okay.
My mom have a procedure done. on
Can we
that day.
change that date? Because her mom's having a procedure done that day.
Unless she can let me come in like 1, 2.
We'll do the 27th.
Okay.
At 8:30. And may I have a good contact number for you?
470-429-0951.
Failure to report on September 27th, 2024 to the Atlanta Probation Office at 8:30 a.m. will result in a warrant for your arrest. Do you understand?
Yes.
Good luck to you, Ms. Henderson. Thank you.
Thank you.
All right, we will be in recess until 1 o'clock. Thank you.
Oh, it still say
Okay. Ms. Clark, question. Previon or McGriff? One of those is going on the October trial calendar. And so one of them, you're gonna need to lean hard on the GBI to get done what they need to get done. Which of the two would you prefer? Or do you want to get back to me before the sun goes down today, which is before 8 p.m.? Today's the first day of a less than 8 p.m. sunset. Yes, get back to Ms. Nelson as well. All right. One of them's going on. Okay, what are we doing next? I think we had talked about doing walls next, but I've been out of the courtroom for a little bit. Did a lawyer end up getting here for you, Miss Markey?
Well, I think she was sending, senior.
But that person's not here yet?
Marcia, can you?
That's the name we had heard, yeah.
Yeah, I've never met her. I don't know what she looks like, but I'm just waiting on her.
Okay, she hasn't, there's no one named Ms. Ginyard in here? Okay, all right, then let's do Mr. Walls. Nope.
Can we do one in front of it?
Sure, as long as we got something else, let's do it.
We can do,
Is Shanahan still up and do we need to keep Shanahan up?
She's up and we can bring her out. I'm assuming my counter offer is rejected, so ready to bring her out whenever.
Well, don't assume.
It's the same offer that I rejected previously.
Okay, so if it's still rejected, but let's do the plea and then we'll bring the Shanahan out and keep things moving. At 2:00-ish, you're welcome to stay right here. I have to shift the Zoom conversation to a civil case. And then we'll get back to doing what we need to do.
While we're waiting to bring him out, I had a quick question, Your Honor. Ms.
And who are we bringing out? I'm sorry, I didn't hear. Oh, Gaiaro, yes, great.
For Carrie Henderson, she just wants to make sure she understands, can she watch the trial can she come and watch the trial?
Sure.
Okay,
It's just like no hand signals and like, hey, here's where you get the widow to say this but it's her son's trial,
Yeah,
so.
that's what, okay, yeah.
Yeah. Yeah. Good afternoon, Mr. Gao.
Good afternoon.
How are you?
All right.
Good. Ms. Rios tells me that you're prepared to enter a plea in your case. Is that correct?
Yeah, that's correct.
Great. Let me make sure that our court reporter, Ms. Hawkins, are you ready to go?
Yes, sir.
Great. Then let's do it. Mr. Gaiaro, this is 23 SC 191315. And you're going to be entering a plea. Ms. Nix, the prosecutor, will put you under oath. She's going to ask you a bunch of questions. If at any time you've got a question, let Ms. Rios or me know so we can address that. Will you do that?
Yeah.
Okay. Ms. Nix.
Thank you, Judge. Mr. Gaiaro, please raise your right hand. Do you swear or affirm that any statements or testimony that you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
You can put your hand down. Please state your true, correct, and legal name.
Juan Gallardo.
Are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No.
Is there a medication that you normally take that you have not taken or been given today?
No.
How old are you?
42.
How far have you gone in school?
High school.
Do you understand the English language well enough to do this plea, or do you need a Spanish interpreter?
No, I'm good.
And for the record, my experience in many interactions now with Mr. Gaiaro is that his English is more than sufficient and that he should be fine. But again, if someone says something and it's not a familiar term, just have us pause and we'll use a different term, okay?
All right.
Do you understand that you've been charged with the following offenses? Count 1, trafficking in illegal drugs. Count 2, possession of a firearm by convicted felon. And count 3, possession of a firearm during the commission of a felony.
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes.
Do you understand that if you plead not guilty or remain silent and refuse to enter any plea at all, then the state is required to prove the charges against you at a jury trial?
Yes.
Have you had the opportunity to review your rights with your attorney?
Yes.
Have you had enough time to speak with your attorney about all of the charges in this indictment against you, including the facts and circumstances relating to each charge?
Yes.
Do you need more time to discuss the case with your lawyer, Ms. Rios?
No.
Are you satisfied with her services?
Yes.
Ms. Rios, do you waive a formal reading of the indictment for purposes of the plea?
Yes,
And do you waive any and all defects in the indictment for purposes of the plea?
I'm unaware of any defects, but I do waive for the purposes of the plea.
Mr. Gallardo, do you remember having been arrested on these charges?
Yes.
Has your attorney advised you of the minimum and maximum sentence for each charge to which you're pleading guilty today?
Yes.
You understand that today you are entering a negotiated plea of guilty, which means that the state will recommend the following sentence to the court.
Yes.
As to count one, the state will reduce to trafficking tier 1. The indictment says possession of 400 or more. The state will amend it to the 28 grams or more. So it's tier 1. And recommend a sentence of 10 years in custody. As to count 2, the state recommends a 5-year sentence probated to run consecutive to count 1, and count 3, a 5-year probated sentence to run consecutive to count 1 and concurrent with count 2. Conditions of probation are that you forfeit this all seized property, complete 200 hours of community service, and submit to random drug screens. Judge, there is a statutory mandatory fine, but I believe it can be suspended, and so that's what the state would recommend.
Okay, what is the fine amount?
$200,000.
Oh, okay.
Mr. Gallardo, do you understand that's the state's recommended sentence?
Mm-hmm.
Yes.
Yes.
You understand that the court is not required to accept the state's recommended sentence?
Yes.
You understand that the court has the right to sentence you to the maximum possible sentence on each charge?
Yes.
Do you understand that since there are multiple charges to which you're pleading guilty today, the court also has the right to run those sentences consecutively?
Yes.
Do you understand that if the court were to order a sentence that differs from the negotiated plea you are expecting today, you do not have the right to withdraw your plea of guilty?
Yes.
Are you currently on probation or parole anywhere?
No.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit?
Yes.
Do you understand that while you're on probation, you must follow all the special conditions of your probation?
Yes.
Do you understand that if you were to fail, if you failed, let me start over. Do you understand that if you fail to follow all of the special conditions of your probation, then you'll be subject to revocation of that probation for the balance of your sentence?
Yes.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes.
Are you a United States citizen?
Yes, I am.
Do you understand that by pleading guilty to a felony, you may not receive, possess, or transport a firearm? Do
Yes.
you understand that doing so could result in new criminal charges for which you face a sentence of up to 10 years?
Yes.
Do you understand that by pleading guilty to a felony, you also may not use a firearm in a crime in the future?
Yes.
Do you understand that if you were in the future to use a firearm during the commission of a crime, you would face a 15-year custodial sentence consecutive to the sentence for the underlying crime?
Yes.
Do you understand that by entering a plea of guilty today, you are waiving any and all defenses, including any mental health defenses?
Yes.
Do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, to remain silent, to confront witnesses against you, to the assistance of counsel, to the presumption of innocence, and the right to appeal if convicted of these charges at trial?
Yes.
Is it your decision to waive these rights and enter a guilty plea today?
Excuse me. Then.
Is it your decision to waive the rights I just read and enter a guilty plea today?
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to enter a guilty plea because you are in fact guilty?
Yes.
How do you plead to the charges of trafficking in methamphetamine, possession of a firearm by convicted felon, and possession of a firearm during the commission of a felony in indictment number 23 SC 191315?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you? Do
Yes.
you understand that you have only a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition?
Yes.
Do you understand that since these are felonies, you have only 4 years from today to do so?
Yes.
Judge, had this case gone to trial, the state would expect the evidence to show that on or about June 8th of 2023,
I've got February 14th, Valentine's Day, 2020. Whoops, I got the wrong indictment up. Never mind. Wait, what? Back to you.
Officers conducted a traffic stop on a vehicle being driven by Mr. Gallardo. Mr. Gallardo gave them consent to search the vehicle, and in the trunk, they found over 28 grams of methamphetamine. The defendant also had a firearm on his person after having been convicted of aggravated assault in Texas in 2017 and possessing that firearm during the commission of trafficking methamphetamine.
Okay, I have a question about the reduction. So it's still trafficking, it's just to that more than 28, but less than 400, so tier 1.
Yes.
Okay, got it.
Because the indictment says over 400, so we would just need to.
Got it. Okay. Ms. Jackson, good afternoon. Criminal history information that you have for Mr. Gallardo, please.
Yes, Your Honor. I wrote down the wrong date. Can I have just a moment? And I apologize to the court, Your Honor.
No, not a problem. Take your time. Let's turn to you, Ms. Rios.
Yes, Your Honor, Mr. Gallardo, it's actually Gallardo, but they put it in the system wrong.
Oh, there's a D in there.
Yeah.
Okay, and do we say the 2 L's? Like Gallardo, or is it like a Y? Like
Gallardo.
Gallardo.
Yeah.
Well, we've been butchering your name. I apologize, Mr. Gallardo. Now you tell us, after a suppression hearing.
I just found out.
Okay.
Okay. He's 42 years old. He is a high school graduate. He works in construction. He is from Texas. He was actually only in Georgia for a construction job. I'm asking that you accept the plea as negotiated. I know he has some history, but it doesn't seem like it's an extensive history. And I think this is a fair resolution to the case.
Okay, Mr. Gallardo, anything you want to add?
No, Your Honor.
Where was the gun found? It was on Mr. Gallardo, or it was just in the vehicle? I don't, we watched a lot of video and I don't remember the officers finding something on him.
It was on me.
It was on you.
Yes.
Okay, there you go. All right. Ms. Jackson, you ready?
Yes, sir, Your Honor.
Just in time. Okay.
He has 6 cycles. The last arrest was September the 29th, 2017, out of McLean, Texas, for aggravated assault and obstruction or retaliation, a felony. He does have 1 prior felony conviction that was in 2017 out of Texas for aggravated assault and assault on a family member. And he does have a misdemeanor conviction. It was in 2014 out of Texas for assault and interference with emergency required for assistance. Nothing in addition, Your Honor.
Thank you, ma'am. Mr. Gallardo, anything that you want to add?
No, I'm good.
You're good. Okay. Well, I don't always hear that. I'll take that. Mr. Gallardo, I'm pretty familiar with the general facts, at least of the car being stopped and what was in the car, not necessarily what made you and that car so interesting to the police. But I do find there's a factual basis for your plea, and that your plea is knowing and voluntary, meaning you've understood what we talked about and no one's forcing you to enter this plea. Do you agree with that?
Yeah.
Okay, then I'll accept it. I'm sentencing you pursuant to the Probation Options Management Act, which means that while you're on probation, you will, if you have a small violation, that's you and probation will work through that. But if it's more significant, typical examples, if you get arrested for anything, that comes back to me and we'll work through any consequences. I was clearly reading the wrong or looking for the wrong indictment when Ms. Nix asked you about your citizenship. Are you a U.S. citizen?
Yes, Your Honor.
Okay. Then this conviction has no impact on your citizenship or your ability to stay in the United States. But home for you is somewhere in Texas.
Actually, I was born in California. My whole family lives in California.
Where in California?
Orange County.
Okay. Well, you're even further away from home. So I will follow the negotiated resolution. for the most part. I think the way I need to sentence you, and I will, is that it's 10 years to serve on count 1, 5 years to serve concurrent count 2. Count 3 has to be consecutive and has to be 5 years, but I'll probate that. So the total sentence is 50. It's the same as what was negotiated, it's just structured a little differently. It's 15 years to serve 10 years with a balance on probation. Importantly, you'll get credit for every one of the 456 days you've already been in jail. So this is a parolable offense. You will parole out. Drug cases do parole out. And you're already a year and almost a half into whatever your term of imprisonment will be. Special condition of probation number 1, you forfeit everything that was seized. So when you get out, don't try to get the drugs back. Don't try to get the gun back. That's not yours anymore. If it ever was yours, it's gone. I'm going to impose only 80 hours of community service. And there is a mandatory fine of $200,000, but I will suspend that. I reserve the right to unsuspend it if I read in the newspaper that you won the lottery. And if you suddenly have $1 million, a fifth of that will go to the government as your fine in this case. I think I covered everything other than signing. Anything else, Ms. Rios?
No, Your Honor, thank you.
We can sign on your behalf. Ms. Nix, anything else?
I had asked for random drug screens, so.
You did, but
Is that the-
I didn't forget about it. I left it out given the length of his incarceration. All right,
Then you can sign for me.
we will sign for you. Mr. Gallardo, is it okay if we sign your name electronically to the indictment?
Yes.
Okay. Officer Evans, I'm assuming we don't need to give Mr. Gallardo reporting instructions beyond when you get released, you need to report to probation.
That is correct, Your Honor.
All right, when you are about to be processed out, they're going to give you reporting instructions. Is driven by where you're going to live when you get out. One piece of information, if you're thinking once I get out, I'm going to California or going to Texas, the answer unfortunately is not so fast. Your probation can be transferred to Texas or California, but that process takes a few months.
Okay.
And so you would need to be ready to be in Georgia, anywhere in Georgia, for a few months while all that paperwork is being done to get the probation transferred. Okay?
Okay.
All right. Thank you, everyone.
Thank you, Your Honor.
Ms. Nix, before you go too far and we pivot to Mr. Walls, Walls is next. What are we doing with Mr. Romero Silva?
If I could answer that later today or later this week.
Okay, should I give you the same by sunset today, or you need a little more time because you gotta corral the people who were here earlier in your office?
I need to, I guess, speak with them, and it might be that I can get that information today, it might not be.
Let's say end of week, which is end of tomorrow. Okay. All right. EOW answer. Thank you. Mr. Adams, come on up. So, Mr. Walls, I'm Judge McBurney. I haven't actually seen you in a long time. You've been working through some other things, but I know we met before.
Yes, sir.
The paperwork I have is for one of the cases and not both. Are we taking a plea in both cases or one?
Just one, Your Honor. With the plea of this case, the state will be no crossing the other case.
Got it. So, Mr. Walls, assuming the plea goes through for the case where you're charged with some counts of aggravated assault, if that goes through, then Ms. Clark will be dismissing the other case where you're charged with drugs and a gun.
Yes, sir.
Okay. So we are dealing then with position 8 on the trial calendar, State versus Walls. Mr. Adams, who is now Mr. Walls' attorney, is here in court with Mr. Walls. Ms. Clark is handling the case for the state. And Mr. Walls, in just a moment, and I need you to stay focused this way and not on those folks. In just a moment, Ms. Clark's going to put you under oath. And she's going to ask you a bunch of questions, but they have a whole lot to do with the paperwork you already filled out with Mr. Adams, okay?
Yes, sir.
If at any point you've got a question, let me know.
Yes, sir.
All right, Ms. Clark.
Thank you, Your Honor. Please raise your right hand.
That's as high as I can get it.
That's good.
Do you swear or affirm that any evidence or testimony that you shall give in the matter currently pending before this court shall be the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, ma'am.
You can put your hand down. Please state and spell your correct legal name.
Prometheus Narcissus Walls.
Are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No.
Is there a medication that you normally take that you have not taken or been given today?
I'm taking like a gabapentin for my pinched nerve. It's till later on today though.
Just a painkiller?
Yes.
Okay.
How old are you?
I'm 51.
What's the highest level of
High school
education?
and trade school.
Are you able to read, write, and understand
Yes, ma'am.
So Mr. Walls, you got to let her finish because the court report, it's not Jeopardy where you can buzz in early. Ms. Clark needs to make the record, and there's a court reporter who you can't see, but is taking all this down. And when you talk over Ms. Clark or she talks over you, the transcript gets messy. So I know you know what's coming, but wait till you see that question mark in the sky, then you can answer the question. Thank you.
Are you able to read, write, and understand the English language?
Yes.
Do you understand that you've been charged with the following offenses? Counts 1 through 5 are aggravated assault. Counts 6 through 10, criminal damage to property in the first degree. Count 11, possession of firearm or a firearm during commission of a felony. Count 12, use of a firearm by convicted felon during commission of a crime under 1611-133. Counts 13 through 16, criminal damage to property in the second degree. Count 17, use of firearm by convicted felon under 1611-133. The state will be no processing count 18. Count 19, burglary in the first degree, and count 20, possession of firearm or knife during commission of a felony.
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes.
Do you understand that if you plead not guilty or remain silent, then the state is required to prove the charges against you at a jury trial?
Yes.
Have you had an opportunity to review the indictment with your attorney?
Yes.
I need you to one more time, that my list isn't numbered. The calendar's not numbered and I'm pulling up the indictment. Whichever is easier, telling me the counts that are being null prossed or the counts you're going forward on, the shorter of those
Okay.
two lists.
Count 18 is the only one I'm null prossing, Your Honor.
Okay, so this is a guilty plea to 19 of the 20 counts.
Yes.
Count 18, a theft by taking, is off the table.
Yes, Your Honor.
Got it. Thank you.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes.
Do you understand that if you plead not guilty, have you had the opportunity to review your indictment with your
Yes.
attorney? And did you understand the indictment as explained to you by your attorney?
Yes.
Did you have an opportunity to review your waiver of rights
Yes.
with your attorney? And did you understand your waiver of rights as explained to you by your attorney?
Yes.
And did you sign the waiver of rights form with your attorney?
Yes.
Your Honor, the state moves to have the waiver of rights form signed by the defendant and his counsel into the record.
All right, before we do that, let me just verify the signature. So Mr. Walls, I'm holding a form. I can give it to Deputy Gordon in a minute so you can look at it, but this is what you and Mr. Adams went over. So I'm gonna hand it to Deputy Gordon. If you would confirm your signature on page 4 and Mr. Adams can confirm his on page 5.
Yes.
So that's the form Mr. Adams went over with you.
Mhm.
And you sign it on page 4 indicating you understood it.
Yeah.
Okay, and Mr. Adams, you signed on page 5?
Yes, Your
Great. Then I will make that waiver of rights part of the record.
Thank you, Your Honor.
You're welcome.
Have you had enough time, Defendant Walls, to speak with your attorney about the indictment against you, including the facts and circumstances relating to these charges?
Yes, ma'am.
Are you satisfied with your attorney's services?
Yes, ma'am.
Attorney Adams, do you waive a formal reading of the indictment?
We do,
Do you waive any defects in the indictment for purposes of this plea?
we do.
Defendant Walls, has your attorney advised you of the minimum and maximum sentence for the charges to which you're pleading guilty?
Yes, ma'am.
The state will put those on the record. For counts 1 through 5, they're all aggravated assault. The minimum is 1 year in jail. The max is 20 years in jail. For counts 6 through 10, criminal damage to property in the first degree, the minimum is 1 year in jail. The max is 10 years in jail. For possession of firearm during commission of a felony, the sentence is 5 years consecutive to whatever the sentence is in the case. For count 12, use of firearm by convicted felon under OCGA 1611-133, the sentence is 15 years confinement. That is consecutive to whatever the count is, whatever the underlying charges are. Counts 13 through 16, the minimum is 1 year, the max is 5 years in prison for criminal damage to property in the second degree. Count 14 is burglary. In the first degree, the minimum is 1 year, the max is 20 years in prison. Count 17, use of firearm by convicted felon during commission of a crime under 1611-133, same sentence is 15 years confinement consecutive to the crimes is charged. Count 19 is burglary in the first degree, 1 to 20 years in prison. And then count 20, possession of firearm during commission of a felony is 5 years consecutive. So those are the minimum and maximums for that entire indictment. Is that your understanding?
Yes.
Do you understand that what you're entering is a negotiated plea of guilty,
Yes.
which means that the state and defense jointly will recommend the following sentence to the court? Overall, Your Honor, the state's recommendation is 35 years to serve, 18 in confinement, balance probated. The count 1 through 5, the state's recommendation is 15 years to serve. Those sentences would run concurrent to counts 2 through 10, 13 through 16, and count 19. And that will be the sentence for counts 1 through 5. For count 6 through 10, the state's recommendation would be 10 years to serve, concurrent to counts 1 through 5, 7 through 10, 13 through 16, and counts 19. For count 11, the state's recommendation is 5 years probation. The sentence is consecutive to counts 17 and 20. For count 12, state's recommendation is 15 years to serve. That is consecutive to counts 1 through 10, counts 13 through 16, and count 19. Criminal damage to property, count 13, state's recommendation is 5 years to serve. That would run concurrent with the above charges that are non-weapons charges. Count 14, burglary in the first degree, the state's recommendation is 20 years to serve. Sentence runs concurrent to counts 1 through 10, 13, 15 through 16, and count 19. Counts 15 and 16, the state's recommendation on criminal damage to property in the second degree will be 5 years to serve. Sentence runs concurrent to 1 through 10, 13 through 16, and count 19. For count 17, the state's recommendation for the firearm by convicted felon would be 15 years to serve, consecutive to 1 through 10, 13 through 16, and count 19. Count 18, theft by taking, the state will be null processing that charge. Burglary in the first degree is count 19. The state's recommendation is 20 years to serve. Sentence runs concurrent to counts 1 through 10, 13 through 16. And count 20, State's recommendation would be 15 years to serve consecutive to 1 through 10, 13 through 16, and count 19. As part of this plea, in this case, the defendant has voluntarily signed a permanent protective order, which will require him to remain at 200 yards from all the victims in this case. Special conditions of the probation: once defendant is released, he will complete a mental health and drug evaluation within 30 days from his release of custody. Stay away from the incident location, 1615 Stonebriar Way, South Fulton, Georgia, 30331, and 625 Stonebriar Way Southwest. Stay away order from the victims and their family members: Ryan Adams, Malaysia Adams, Danielle Adams, Saeed Adams, spelled S-A-E-E-D, Johans Mitchell, spelled Y-O-H-A-N-C-E, Deanna Mitchell, spelled capital D-I, space, capital Y-O-N-N-A, and the minor Mitchell child with the initials A-L-M, and the minor Mitchell child with the initials A-D-M, and no contact order with the victims in this case. Is that your understanding of the terms of the negotiation in this case?
Yes.
No, Your Honor, we need clarification on several items. You read off 15 to serve consecutive on 3 cases. That's 3 counts.
Right. I was going to ask about that as well, because that adds to 30. We just need to figure out how we are navigating the firearms counts, because, and you may have misspoken, it's lots of counts. But what you said to me is that count 12 is 15 years to serve consecutive to, for example, count 1, but that would be 30 years to serve. And I thought that the recommendation overall was 35 to serve, 18 balance probated.
Yes, it is.
So if 12 is 15 years to serve, and that's consecutive, let's just take count 1, 15 years to serve. Isn't that 30 years to serve?
Well, Your Honor, it will be 30 years, but then that is why count 11, the possession of firearm, is the 5 years probation, making it 35 years.
Right. I'm not worried about the 35. I see how you get there, but I thought that the overall sentence, forget about probation. What you all agreed is that Mr. Walls is going to serve 18 years.
Yes.
Okay. So, and let's say that all you were going forward on is count 1 and 12. How many years is he serving based on how you describe?
My apologies. It's 18. It's 8. So counts 14 will be for the burglary will be 18.
Okay, I see that. So 14 does need to be 18 because the most he would get is 18, but I'm focused on 12. 12 says 15 years to serve consecutive to, just as an example, count 1. So 15 plus 15 is 30,
right?
But you're saying serve 18 is the sentence.
I think you meant to say 15 probated.
I don't know. It's not what you did say, but that's what I need to understand. It's 2 things. Did you mean for count 12 to be probated? It's consecutive to the 15 to serve for aggravated assault. And can you probate 133?
No, it's not. It's not probated. It would be count 19 is it's going to be 15 years on count 12.
Okay.
That would be consecutive to the aggravated assault counts 1 through 5, which is 15 years.
Right. So what's 15 plus 15?
30.
30. But you told me, I thought at the outset, that it's 18 years to serve, not 30 years to serve.
Right.
Okay. So what am I missing?
So on the burglary in the first degree, instead of the 20, it would be 18.
Okay. I'm good with that, and that would have to change for count 19 as well. But are you probating the years for 130 for count 12? Are you probating those?
No.
Okay. Then how is it not 30 years to serve instead of 18? Because it's 50. Forget about all the other counts. Let's just say you no-prossed everything except for count 1 and count 12. What is the sentence that you're recommending for Mr. Walls? That's 30 years to serve. I don't think that's what was negotiated. I can build a sentence of 35 to serve 18, if that's the goal.
That's what the goal was. And because of, I guess, negotiations going back and forth, my numbers have gotten off, but.
Okay, but as long as you weren't unintentionally, well, I guess it would be intentionally trying to, and I don't mean it this way, it's gonna sound wrong, try to sneak in 30 years to serve.
No.
You always intended it to be 18 years to serve, followed by a whole bunch of probation, then we can manage this. And I haven't heard everything, and I'll let you know if I'm not gonna follow the recommendation, but I intend to follow the recommendation, at least of the 18 years to serve, given what these charges look like. And I'll sort out the probation piece that would follow. But I'm hearing Ms. Clark say that overall, no matter how one structures it, it's 18 years to serve, followed by some amount of probation. The way she's built it, it would be 17 years of probation. I don't know that I'll impose that much probation because I'm not a big fan of really, really long probated sentences, but there are instances where it makes sense. Does that address your concern, Mr. Adams?
It does, yeah.
Okay, then when you're ready, Ms. Clark.
Okay. Do you understand that the court is not required, have you discussed the offer? Strike that, sorry. Do you understand that the court is not required to accept the state's recommended sentence?
Yes.
Do you understand that the court has the right to sentence you to the maximum possible sentence on each charge?
Yes.
Do you understand that as there are multiple charges to which you're pleading guilty today, the court also has the right to run those sentences consecutively, meaning one after the other?
Yes.
Do you understand that if the court decides to order a sentence that differs from the negotiated plea you were expecting today, that you do have the right to withdraw your plea and demand a jury trial?
Yes.
Are you currently on probation or parole?
No.
Do you understand that if you're on probation, you must follow all the special conditions of your probation?
Yes.
Do you understand that if you fail to follow all the special conditions of your probation, then you'll be subject to revocation of that probation for the balance of your sentence?
Yes.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes.
Do you understand that even after you're off probation as a convicted felon, you are never to carry a firearm?
Yes.
Are you a United States citizen?
Yes.
Do you understand that by entering a plea of guilty today, you're waiving all defenses, including any mental health defenses?
Yes.
Do you understand that by pleading guilty, you're giving up the following rights? The right to trial by jury, the right to remain silent, the right to confront witnesses against you, the right to subpoena witnesses, confront witnesses against you, the right to subpoena witnesses on your behalf, the right to testify or offer other evidence, the right to the assistance of counsel, the right to the presumption of innocence, the right not to incriminate yourself, and the right to appeal if convicted of these charges at a trial. Is it your decision to waive these rights, which means not to use them, and to enter a guilty plea today?
Yes.
Has anyone forced, threatened, coerced, or promised you anything to get you to enter this guilty plea?
No.
Is it your decision to enter a guilty plea because you are in fact guilty?
Yes.
As to indictment 23 SC 187874, how do you plead to the charges within the indictment?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that if you wish to file a direct appeal, you must do so within 30 days from today's date?
Yes.
Do you understand that if you wish to challenge what is called the voluntariness of your guilty plea, you must do so by filing what is called the habeas corpus petition?
Yes.
Do you understand that for a felony charge, you have only 4 years from today's date to file that petition?
Yes.
Your Honor, if this matter would have went to trial, the state would have been able to prove beyond a reasonable doubt that the defendant in this case, Prometheus Walls, got into a dispute with a former employer and came to his home on the day of August 17th, 2022, and shot up his vehicle or truck out there. A police report was made by the victim, Mr. Adams, in this case. in that same evening, at the incident location, excuse me, Mr. Adams's address is 615. I should know it by now. 615 Stonebriar Way, Southwest, South Fulton, Georgia, 30331.
That's Mr. Adams's.
Yes, that's
Okay.
Mr. Adams. The defendant returned later that evening, and shot up the home of the Mitchell's home, which is the 625 Stonebriar Way, Southwest, South Fulton, Georgia, 30331. Your Honor, the state would like to point out, as part of the evidence for this particular case, the state would have been able to prove identification. Ryan Adams was in his garage at the time when the defendant came out and actually shot toward the that victim, Mr. Ryan Adams, at his home, but continued to shoot in this case. Mr. Johannes Mitchell, victim that lived in the residence of 625, the next door neighbor, indicated that a bullet went past his head, and he was almost shot. Also, Your Honor, evidence in this case shows that the defendant shot into Mr. Adams's when he was shooting in the garage, also shot to the upper bedroom above the garage. There is evidence of bullet holes through there, but for Mr. Adams's son not being in his room, this could have potentially been a different case of murder. The defendant shot multiple times into the Mitchell's home, and there was the children at that time were 4 and 9. After that, Your Honor, the defendant returned to the Mitchell's home at 9:25, and he is seen on surveillance footage, and actually did a lot of damage to the home, just a lot of damage to the home. So he's ID'd from that perspective. Next, Your Honor, the defendant came to the home again. Fortunately, the Mitchells were not at home for the second incident. They were actually in fear for their lives, staying with in-laws at the time, and were notified by their security company that the defendant was in their home. The defendant returned again on the incident dates of to the home again on September 1st, 2022, September 8th, 2022, and September 9th, 2022. There was a surveillance that was provided by the next door neighbor. The state was going to have that person to testify that she saw the defendant going into the home on the 9/15 day. The police were contacted by her. Also, Ryan Adams's wife saw the defendant in this case the night of the shooting on 8/17, going after the shooting, running back into the woods. There is body camera footage for the 9/15 incident where the defendant is coming out of the Mitchell's home with a gun in his waistband, with a microwave that belonged to the Mitchells. His vehicle was parked in their driveway. It had a lot of the Mitchell's possessions within the trunk of the car. The victims are both on the Zoom call, Your Honor. They would like to make statements. In addition to that, Your Honor, I know that there was some discussion about, there was the defendant making some type of defense.
You don't need to get into that if that's not where it's going now.
Yeah, but I'm just referring to the evidence. And so there are jail calls that indicate based on the discussions of the defendant, that he was well aware of the things that he did in terms of attacking and the attacks and the actions that he did in this case. Your Honor, the defendant, in terms of criminal history, is an ANC recidivist. He has 5 felony convictions, to include a prior conviction in 2004 for possession of firearm by a convicted felon. He has a possession of intent to distribute cocaine. All of the charges are in Fulton County, but the other charges are drug possession cases in this time. The Mitchell's family is on, as well as the Adams family. And we'll start, Your Honor, I think the Mitchells.
We'll actually wait 1 second, because I have a question for you. You explained that, I'm trying to figure out why this happened. And there are some situations where there's no good explanation for this, but you at least provided a motive that Mr. Walls was unhappy with one of the Adamses because one of the Adamses was a former employer. So maybe it's, I was wrongfully terminated or I wasn't paid. But you didn't provide a connection to the Mitchells. Why? What would your theory be as to why Mr. Walls is terrorizing the Mitchell household?
Your Honor,
other than that they're neighbors of the Adams.
Yeah. The state would say that he may have, just based off of how the actual homes are laid, the Adams's driveway is parallel to the Mitchells. So based off of that, the defendant may have believed that the Mitchell's home was Ryan Adams's home.
But there's not a employment connection or my girlfriend or something is connected with the Mitchells or anything like that?
No, there's none of that. There's just a prior difficulty where with Ryan Adams as his former employer, prior to that, after that, him being terminated, there's also an instance where the defendant actually pulled a gun, is alleged to have pulled a gun on Mr. Adams at his business in Austell. That report was taken by Douglas County in this case. And so it's just believed that maybe he was confused because I guess Mr. Adams indicated that.
That's okay. You don't need to speculate. I just wasn't sure if there was a piece that I missed or that you didn't include. Let's get, I'm happy to start with the Mitchells or the Adamses. How do you want this to work?
The Mitchells.
All right. I see there is someone on the Zoom call where it says, Mitchells, if you want to provide a victim impact statement, you're more than welcome to. You don't have to. But I'm happy to hear from you. Let me get you added to the spotlight. Good afternoon. I'm Judge McBurney.
Good afternoon. Thank you very much. My name's Deanna Mitchell, and I would like to provide a victim statement. Thank you for the opportunity. Our family does not know Mr. Walls. However, his actions have wreaked havoc on our lives. The crimes he committed against our family and our home were not just what occurred during each of the 5 incidents. They go beyond those moments and continue to disrupt our daily lives in multiple ways more than 2 years later. On August 17, 2022, it was a typical evening for us until bullets began to spray through the rooms we were in. As my 4-year-old daughter, 9-year-old daughter, and I rushed to our storage room to hide, my heart was pounding, my thoughts were racing, and I was scared. I didn't know if the shooter was going to break in, if my husband was going to have to shoot him to protect us, or if he would kill my husband and come looking for us. I also didn't know if that night would be our last night alive. As a wife, I wanted my husband to be with us so he would be further away from harm's way, but I understood that he was in a position where he needed to protect us and was willing to give up his life to do so. As a mother, I felt helpless, kneeling next to our daughters, trying to cover them, but knowing that if a bullet came through the window near us, I might not be able to keep them alive. After shooting up our home the first time, Prometheus came back several days later and attempted to break in, damaging additional doors and windows. And about a week after that, he came again. He successfully broke in and he shot up our daughter's easel, her loft bed and mattress, our bedroom mattress, and the storage bags and boxes that were in the room where we had initially been hiding the first night of the shooting. He also shot through an oversized mirror above our jacuzzi, and that bullet exited our house and went through the bedroom wall of our neighbor's son's room. He ripped our alarm panel from the wall. His blood was splattered on our wooden floors and smeared across walls in the stairwell and the foyer. And since the police had not caught him, he came a fifth time and broke into our house. He ransacked the family room and destroyed our bedroom to the point where most of our furniture is unsalvageable. Based on insurance, he's caused nearly $50,000 worth of damage to our home. And he also stole things out of our house. And that's when he was finally apprehended by the police while he was doing so. I don't think he was trying to give our neighbor, Mr. Adams, a warning. The first time he shot up our house would have been warning enough. So for him to come back several more times, I believe he was trying to kill our neighbor. And it is only because of God's grace that he did not kill our family in the process. Our home that was shot up was the first home my husband and I bought together. And we knew it was our dream home for that period. We worked hard. Sometimes 20 hours a day, 6-7 days a week to pay off our house in full. And that's something many people aren't able to ever accomplish in their lives. And since we birthed our daughters while we were living there, that's the only home that they ever knew. So I completely broke down when I went back to our house and saw that nearly every window and every door was boarded up like an abandoned building. So as of today, we have not lived in our house for over 2 years. We've gone from being in a peaceful, stable environment to moving 4 times in a little over a year between family members, houses, and rentals. We were nearly killed in our home by bullets flying past us. We hid in fear for our lives there. We've seen the inside ransacked, bullet holes in walls, toys, mattresses, and blood on the floors and walls. So I can't live there. I try to focus on the good things that happened in our family room. Dozens of dance and gymnastics houses. We had a formal daddy-daughter dance during COVID, curling up on the couch every Friday for family pizza night. But my mind constantly goes back to the glass shattering, running for our lives, and then seeing the bullet holes surrounding the areas where we had been sitting when the gunfire erupted. I'm beyond sad and upset because my beautiful memories in our home are tarnished by the violent and repeated irresponsible acts of a man. It's affected my husband tremendously. I won't get into all the details. But just as an example, he drives sometimes more than 4 hours a day to make sure our girls can go to the same school that they were at previously. Initially, he was driving an hour to drop them off at school, an hour back to work, an hour to pick them up, and then an hour home, because our safe homes, unfortunately, were not close to where we lived. Although the fear is not as overwhelming as it was the first year and a half, it's still there. I'm still in counseling and just sometimes feel overwhelmed trying to handle the issues that these crimes have caused while running a business and taking care of kids and the households. Our daughters were deathly scared. Our 9-year-old was afraid to take showers for a while because that's where she was when the gunfire broke out. She even asked if we could take a plate of food to Prometheus
while he was in jail, just as a peace offering to ask him to please leave our family alone. We sought a counselor for her to try to manage her feelings about her near-death experience and being abruptly displaced from the only home she's ever known and having to move from place to place. One night, our youngest completely broke down in tears, and she was 4, pointing to her tablet because it was playing home videos and slideshows. And she just cried and said that she wanted to go back to that age because that was when we could spend more time together and have fun at our house. She's also asked, what if Prometheus goes back to our old house when he gets out of jail and shoots up the new family that's there? And that's not, our daughter shouldn't have to be in fear for her life or fear for the lives of strangers. So she's had frequent and severe chest pain, which doctors believe is due to panic attacks, and that still occurs. Both our girls were scared to go anywhere by themselves, even in a room, use the bathroom, any room we weren't in. They both were diagnosed with PTSD and anxiety, and they both had to have counseling. More than 2 years after the incident, they're finally functioning better, given the traumatic experiences they've been through at such young ages, but they still have triggers and they still possess a fear that no one, especially at their age, should have to deal with. So in addition to the $50,000 worth of property damage, we still have over $100,000 worth of additional living expenses that we've had to pull from our retirement to cover out-of-pocket costs. And then our greatest financial loss is our home. We'll be losing probably between $250,000 and $300,000 in equity so that we can purchase a new home in this market that's comparable to what we had before. So I feel like we're starting from scratch. I'm frustrated, upset, sad, and heartbroken. Things can be replaced, but there's so many intangibles that are gone forever because of Prometheus's crimes. He can't give us back the time we've lost while handling matters relative to these crimes. He can't give us back the money we lost. He can't give us back our beautiful home, and he can't erase the horrible memories we have of every traumatic experience that he's created. And he definitely can't give us back our peace. The only things he can offer that will provide a small bit of solace are a sincere apology for all the physical, mental, and emotional turmoil he's put my family through, and guarantee that he will never cause or attempt to cause harm to any of us ever again. And although I'm furious by his actions, I forgive him. I don't wish any harm on you, but I do want justice to be served and for you to remain behind bars and lose your freedom for a very long time so we can continue to regain our sense of safety and peace, and to increase the likelihood that you don't have the opportunity to hurt or uproot another family the way that you have ours. And I hope that during that time, you can reflect on the hurt and pain that you caused a lot of people in your life. And I pray that you learn how to resolve issues without violence, that you learn to love and gain respect for your life and the lives of others. So I have no idea why we were chosen to go through this fiasco, since we have nothing to do with any of these situations. But I do know that all things work together for the good of them that love the Lord. And even though he shot up our wall that had our house motto on it, which was, "As for me and my house, we will continue to serve the Lord," that is what we'll continue to do. Thank you.
Thank you, Ms. Mitchell. That was very helpful and painful, understandably so, insight into what you and your family have gone through. I often hear from the prosecutors who do a faithful job to explain, here's what happened, but it's necessarily it's dulled down because they didn't live it. They are reporting what they learned from law enforcement, and you're giving us the real life impact of situations like this. I'm sorry that you and your family went through it. And as you've noted, there are certain things that you can't ever get back. My hope is that there is a sense of closure and a sense that justice can be done in some situations, not all, but this one. I think Mr. Walls has a pretty heavy price to pay for what he did to your family as well as the Adams family, which I'm going to hear from in just a moment. I do have one question for you. Can you tell me the county in which you all live now? And I ask only because one of the conditions I'm going to impose, should I put a probationary term on Mr. Walls' sentence, is that you may not live in that county anymore, but it will be that he just stay out of that county altogether. There will be a requirement that he have no contact with your family or the Adams family. In fact, there's a permanent protective order right here, but I just want to layer on additional protections. So do you forecast being in a particular county for an extended time? And if so, what's that county?
We are currently in Cobb County, but we have not been able to find a home that we can afford that's comparable to what we had. So we would like to stay in this area, but it is possible that we may move somewhere else once we find a permanent location.
Okay, that's helpful to know, not that you're struggling to find housing, although interest rates are going down, silver lining there. But at least you're going to try to stay in the metro area.
Yes.
Okay, all right. Again, thank you for sharing. It's not easy to talk about that.
Judge McBurney, are we still allowed more time to share?
So I don't ever want to put a limit on things. So if there's something you feel that Ms. Mitchell didn't cover, because she was very thorough, then I want to give you a chance to do that. I need to hear from Mr. Adams or someone from his family, and we've got more to do on the case. So please add if you think there's something that has not been covered.
Yes, certainly. Thank you. And thank you for allowing us to speak and to share.
I need you to identify yourself so that's on the record as well.
Yes, my name is Johannes Mitchell.
Okay.
And I just wanted to thank you for this opportunity to share. And I just wanted to offer my perspective as the husband in the scenarios that my wife described and what I actually felt throughout that process and the impact that it had on me. When the bullets came spraying through our home, I immediately yelled to the family, "Get down!" And at no time in my life would I have ever imagined being in our home as the provider, as someone who is there to offer that level of safety to my family, that we would have bullets going past our heads in our own home. So the fact that those bullets just nearly missed our heads is something that I will never forget, and is something that we speak of very frequently because of the trauma and impact that it's had. So I wanted to share that as a father. After the police came, that's when we were able to see the gun casings, the bullet casings, and to see this real time in our own home. And then we were able to reflect on where I was sitting and how bullets were right beyond me, right behind my head. There was one bullet that was aimed directly at my forehead. And had it not been for some equipment that was blocking that particular area, I would not be here today. My wife would not be here today because she was running as one of the bullets hit the garage door. So these are things that are something that just, it repeats itself on a daily basis. And we constantly have to keep each other encouraged throughout this process. So I wanted to speak to that initial shooting because in our wildest dreams, we would have never imagined our home being riddled with bullet holes. I also wanted to speak to the initial breaking. Since my wife already provided a detailed account, I just wanted to state that we were in fear for our lives on that initial shooting. And then to see Mr. Walls entering our home and us to actually see it on camera, walking around with a gun, and then to go through the different rooms and see bullet holes in our daughter's bed, a bullet hole directly above our bed. These are things that, and our photo was directly above our bed. So there was no way that we felt that that could have been missed. So we felt that this was an attack on our lives personally. And that's why I had to make sure that I shared some information as well. We're trying to recover from this. And it's something that is truly impacting our lives. As a husband and a father, it's always been my personal goal to ensure my family had a safe, warm environment filled with love, life, and laughter. Our family room was a place, as my wife stated, for many different performances and true opportunities for us to connect as a family. As we move on, one thing is clear. Mr. Prometheus Walls attempted to murder my family, my beautiful, precious family. I cannot believe that although my vehicle was in the driveway, Mr. Walls still chose to enter my home on August 22nd, 2022, with the intent to kill anyone who was home. That thought of the assailant violating our home and shooting at locations where we may have been hiding is a thought that lingers inside. The feeling I have as a man, a husband, and a father are only tempered by God's everlasting love. The feeling I have as a man is something that it resides deeply in within me because I believe in protecting my family. Without God's guidance, without his perfection, without his protection, and without his grace, we wouldn't be here today. God has helped me steer my family ship during this season in our lives. We will continue to press forward and we will continue to pray for justice to be served. My personal request is that Prometheus Walls be fully prosecuted. And I have here denied bond because that's my personal feeling. That's how this has impacted my family. My personal request is that Prometheus is able to connect spiritually. My family prayed and forgave Mr. Walls a long time ago. We have forgiven him for shooting our home from the outside, breaking into our home and shooting inside with the intent to kill, attempting to break in and finally breaking in again. We have forgiven him for nearly murdering all of us. However, we sternly believe in full persecution extended throughout this incarceration. In our minds, Prometheus Walls is a threat to us, our neighbors, and society at large. Due to the actions of Mr. Walls, for the first time while living in our home, we feared for our lives. After leaving our home, we still fear for our lives. Our home will never be the same. We will never be the same. My wife and kids will never spend the night there again. We have a home, but we don't spend the night due to the trauma. We have a home, but we are staying at safe houses because it's unsettling to stay in our own home. Although most of the damages have been repaired, there are still memories of bullets spraying through our home as we enjoyed a quiet family evening. There are still flashbacks of blood smeared on the walls. There are reminders of Mr. Walls saying in the security footage, I was trying to decipher it, something along the lines of tried to murder the whole family. Indeed, he tried to murder my entire family. Although these memories persist, we are grateful to be living. Nearly every day I ask why. Mr. Prometheus Walls, why did you shoot throughout our home and our neighbor's home? Why did you break into our home on numerous occasions and terrorize my family? Why? We are still undergoing a healing process. My wife and daughters have undergone counseling, like my wife said. My wife is she's still in counseling. Just today, my oldest daughter asked me, what about you, Daddy? What kind of care are you getting? I told her I've been making sure everyone else is okay, and I take time every day to speak with God, and he helps me and gives me the perseverance to forge ahead each day. We give God all the glory. I'm grateful to have this opportunity to submit my impact statement. I pray those who are listening to my statement receive this from a person who is a God-loving peacemaker, a visionary, a husband, a father, and a friend. I simply want my family to be safe and for justice to be served. Through our faith, we believe that we are instructed to bless those who persecute us. We bless and do not curse them. God will fight for our justice. He will be our protector and defender. Mr. Prometheus Walls, we pray you repent and turn from your ways. Ask God for forgiveness and accept Christ as your Savior. he can truly change your life. My family and I stand in agreement, honorable judge, and to those court bystanders in attendance, thank you for allowing me to render a summary of my statement. Thank you, Judge McBurney.
Thank you, Mr. Mitchell, in the same way that I thank Jeriah for sharing with us the impact this has had, not just on the two of you, but your children and the continued impact that it has. Again, my hope is that in some small way, today's process moves your family collectively towards a better situation. All right, if you guys want to, you don't have to sign off, but you can turn video off, and then I'll see if there's anyone from the Adams family who wants to weigh in.
You allow him to talk to us?
The Mitchells.
Nope. Mr. Adams?
Hello.
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 Can you see us?
I can.
Great. If you would introduce yourself and then share with me, please, what you want to share about this situation.
Well, my name is Ryan Patrick Adams, and I'm an Atlanta native, and I live at 615 Stonebriar Way. I just wanted to say that the Johans have basically, the Mitchells have basically covered everything I wanted to say and more. I didn't understand the hatred, and I didn't understand the repeatedness of coming back to someone's home and doing that. And one of the bullets came in my son's room right by his head. So if he was home from work, he wouldn't be here today, you know. So I'm not going to hold the court long because I really appreciate what the Mitchells have said. And basically, they have covered every aspect of how I feel and how my family feels and my wife feels as well. And it has not only impacted the Mitchells and us, but we also have neighbors that has impacted too. And these neighbors are older and retired. There's a prominent neighborhood, and they don't understand why this happened. And that's all I had to say, Judge McBurney.
Mr. Adams, thank you for that. I've got a couple questions for you, but I also want to extend the same hope to you and your family that through the process that's occurring today, after long last, it does bring some form of closure, or at least partial closure for you and your family. And I share your gratitude that your son was at work that day and not at home when the shots entered your house. My question is, what is your understanding of the employment connection that you had with Mr. Walls? That's been identified as a potential reason why Mr. Walls decided that the right thing to do in his view was to shoot up your house and your neighbor's house.
Well, Walls inquired about borrowing some money from me, and I wouldn't let him borrow it. And I offered work instead of, I think he asked me for $1,000, and I wouldn't let him use it. So I offered work. At the time, I owned a restaurant in Austell, Georgia, named Fire Restaurant and Lounge. I had over 20-something employees, and we hired different people for guerrilla marketing and promoting around the community in order to get, so that was, a fallout with that, and then him bringing his son by, asking me for money when his son wanted to go fishing or something, and I said some words to him that I probably shouldn't have said. And it was just a whole lot of other things. But what I don't understand is, you went into Mitchell's home several times. I'm sure they have pictures, and I don't know why you just terrorized this family, which affected an entire neighborhood.
Sure. Understood. Okay. I appreciate you sharing that. And most of all, Mr. Adams, just being here and giving me the perspective of one of the victims in this case of the impact that it's had on you and your family. Thank you.
You're welcome.
All right. Deputy, can you adjust the screen a little bit so that it has Mr. Walls on it? I just keep seeing his shoulder. Thank you. That'll help the court reporter as well. Okay. Mr. Adams, your turn. Not sure there's a whole lot to say from the defense side, but I want to give you an opportunity, and then I'll certainly give Mr. Walls an opportunity if he thinks it's wise to say anything at all in this case.
Yeah, Mr. Walls is 51. He was employed with a food company.
Yes.
He suffered a very severe injury and lost and had to get workers' comp. He's taking pain medication, plus he's been on drugs most of his life. Not using that as a defense, but as a, he had a drug problem. And, he does have, I think he's 3 kids, 130, 23, and 15. And some adopted kids. And his family's here with us today in the courtroom. He understands at 18, and we just ask you to accept that recommendation. Since he's 51 now, maybe we can shorten the probation.
Okay. All right. Mr. Walls, in the same way that the Mitchells and the Adams had an opportunity to be heard as the victims in the case, you as the defendant in the case have a right to be heard. If there's anything you want to say, I want to be clear, you and I are the ones speaking, so you can convey a sentiment to anyone you want, but the conversation is Mr. Walls and Judge McBurney, okay?
Okay. To the Mitchells and the Adams family, I would like to sincerely apologize. I was under the influence or something, and I sincerely thank your daughter for offering me some food from the bottom of my heart. I meant to harm no one at the time. It was just I was under influence or something.
What's that something?
Your Honor, I have no idea. When they took me to...
So let me pause you for a second, because you went back to these houses more than once. Were you under the influence of this mystery thing for days at a time?
I was under the influence, supposedly it's supposed to be Molly, but it lingered on me so long that I went to 3 mental hospitals before, and it still was on me. My sister had to call a detox van to detox me at the time, and it did not work. The guy explained to her that it still might affect my memory. And it took me a while to get my memory back. I even told Mr. Adams, I'm sincerely sorry for what happened to both of these families. I wasn't in my right mind at the time. I swear to God I wasn't. My mother's here. She can state some of the things that I went through, what I went through. My sister, my wife was here, but she's gone now. Miss Williams, Miss Rita Williams, also an attorney of the family, she can also state what happened with my mental health issues too. Whatever I took, Your Honor, it stayed on me a long time. And I've never been through a situation like this, never. I'm not saying I'm a model citizen, but I've never been through a situation like this. So from the bottom of my heart, I apologize to both families. To the Mitchells, I sincerely apologize. I hope that you can rebuild. I pray that you can rebuild, because I'm going to do the same thing where I'm going. So to the Adams, I do the same. I apologize the same way. I hope that you can forgive. Eventually, you know, you'll never forget, but you can forgive. If God willing, you will see someday or not see my change. But that's for me and God to deal with and my family. So I just thank you for giving me your statement and being here today.
Okay. Well, Mr. Walls, I do find that there is a factual basis for your plea. I think that you and Mr. Adams made a very wise decision not to go to trial and to see what is the least severe penalty you could get for the terror that you inflicted in both those households. And you've heard very emotionally and sincerely how it persists for both. I'm relieved that Mr. Adams has been able to stay in his house, but you've heard how the Mitchells effectively are on the run still, run from the fear of what you did.
Mr. McBurney, they don't have to worry about me ever again.
I think today is part of that process. I also find that your plea is knowing and voluntary. Knowing means you've understood all the things we've discussed. Is that a fair statement?
Yes, sir.
Voluntary means no one has forced you to enter this plea, but that you've decided after consulting with your family and with Mr. Adams that this is what you want to do. Is that correct?
Yes, sir.
Okay, then I will accept your plea. I'm sentencing you pursuant to the Probation Options Management Act. What that means is that while you're on probation, and part of your sentence will involve probation, if you have a minor violation, and an example of a minor violation would be you miss a meeting, or if you're not supposed to be using a particular substance and you use it and you test positive, you don't need to come back and see me. But if you get arrested again, or there's any evidence that you are trying to attempt to have any contact with any of the people that you're supposed to stay away from, that will come back to me. As for the question of restitution, and I think it was alluded to by the Mitchells, I'm going to leave that to Ms. Clark. And if she thinks that a restitution hearing is appropriate, we'll schedule that, Mr. Adams, so you can be here, and Mr. Walls, and the state could put up whatever evidence it has to justify the entry of a restitution order. So, Mr. Walls, I'm going to sentence you a little differently than what was negotiated. I'm not bound by that negotiation. I do think that a very, very serious sentence is appropriate, but I think that your acceptance of responsibility and not putting, in particular, the children that are involved through a trial merits recognition as well. And so as I was first hearing from Ms. Mitchell in particular about what happened and what this has done to them, I was thinking of bigger and bigger and bigger numbers. But the more I thought about it, the more I appreciate the step you've taken to say, I own this. And you've helped me understand what might have been behind it. To Mr. Adams's point, it might explain it, but it in no way excuses it. There's no excuse for what happened. And whether you were high or not, strung out or not, it doesn't mean that, oh, he was just high, I'm not afraid anymore that our house got shot up, or that this man repeatedly entered our house, or anything like that. It makes none of the concerns we heard from the Mitchells or the Adams any less serious or severe or persistent. So what I'm going to do is sentence you overall to a term of 30 years to serve 20 years with those remaining 10 years on probation. And here's how it's structured. Counts 1 through 10 are all 5 years to serve. And I should add, you get credit for all the time you've served. So as you're thinking through the math, the time you've been in gets credited to your sentence. So 1 through 10 are all 5 years to serve, concurrent with each other. Concurrent with count 1 is count 13 through 16. Those are all 5 years to serve. And count 19, which is 5 years to serve. Consecutive to count 1 is count 12, which has to be 15 years to serve. And count 17, which has to be 15 years to serve. Those are run concurrently with each other. And so that's a total of 20 years to serve. Consecutive to count 12 is count 11. That's 5 years, that's probated. Consecutive to count 11 is count 20. That has to be 5 years, that's probated. I believe all that math adds up to, and it should, 30 years to serve 20 with the balance on probation. Count 18 is being dismissed by the state. Special condition of probation, you stay away from Stonebriar Way. Where is it that you would expect to live when you get out?
Where's my sister? Even my sister.
Okay, I don't know. I don't need a street address, but okay, so maybe not your sister.
That's my mother right there talking.
Okay, but what county would you be in?
Fulton.
Macon? Mableton. Okay. What county is that? That's Cobb. So you're not gonna be in Cobb County. So you got some time to think about it, but you're gonna need to stay out of, while you're on probation, Cobb County and Fulton County. That builds in the stay away from Stonebriar Way. When you are released from custody, you'll need to submit within the first 60 days to a mental health and drug and alcohol abuse evaluation. And if any treatment is recommended, that course of treatment will become part of your probation. I will waive your probation supervision fees while you are on probation, because given the age when you get out, my guess is you're not going to be doing a whole lot of work. You indicated on your waiver of rights that you had been taking some medication. Is that the gabapentin you mentioned?
It's not, I forgot the name of it, but it's like gabapentin.
It's a painkiller.
Yes, for my pinched nerve.
But
I
that
used to
doesn't,
take tramadol, but they took me off the tramadol, but I still take it when they give it to me.
okay, but that does not affect your ability to understand what we're talking about. And then at some point, you've received some mental health treatment, and that may have been at the time you were just talking about. When's the last time you talked with a doctor or a counselor?
It's been a while.
Okay. The fact that it's been a while, does that make it difficult for you to understand what we're doing today? No? Okay. All right. Ms. Clark, anything else on behalf of the state?
No, Your Honor.
Can we sign the indictment electronically? Can my office on your behalf?
Yes, Your Honor.
Mr. Adams, can someone in my office sign the indictment on your behalf?
I can, yeah.
And Mr. Walls, we don't pass the documents around so much anymore. Is it okay if we electronically sign your name to the indictment?
Yes.
Okay. And Ms. Clark, given Mr. Walls's guilty plea, is the state moving to dismiss or null pros his other case on the trial calendar?
Yes, Your Honor, we are.
All right, I'll make sure that that happens. So 23 SC 187869 will be dismissed.
Your Honor, I'm sorry. We're asking though, the guns confiscated at the time of that arrest, the handgun that was confiscated.
Oh, was something seized from him when he was arrested?
Yes,
Okay,
Your Honor.
I'll add as a
Okay.
special condition of probation that whatever weapon you had on you when you were arrested is forfeited to the state. So they'll destroy it, do whatever they do, but just don't send someone to try to get that back. Mr. Adams, anything else? And thank you for your service on behalf of Mr. Walls.
As part of the guilty plea, the state agreed to withdraw the recidivist notice.
Thank you for flagging that. I'm assuming this is a non-recidivist sentence.
Yes, Your Honor.
That's a pretty significant concession because that means you're eligible for parole. If you had gone to trial, you wouldn't have been, but that's where you are. All right. Thank you, deputies.
My mom and my sister.
So he's wondering if it's possible.
Can I give my family a hug before I go?
No hugs. You can wave to them, but the deputies are real quick.
Give me a kiss.
So now's not the time, ma'am.
You should have told the truth.
No, mama.
Okay. So Mr. Walls, they can come visit you, but I'm gonna have the deputies take you now. Thank you, Mr. Adams. All right, I have about a dozen lawyers on the Zoom call that I'm supposed to talk to at 2 o'clock, and it's 2:40 later than. So I'm gonna talk to them in just a second. Let's just get a few updates about what remains. Ms. Shanahan.
I need to speak with her once more.
Okay.
It will be a plea as soon as I find where you went.
Okay. And what about Merkey?
Good afternoon, Your Honor.
Hey, how are you?
Good, how are you?
Well,
We are in the process of hopefully resolving this case today. There's some information that Madam Prosecutor requested, so I'm trying to get that sent over, but I'm hopeful that it's come off your docket.
okay. And if we can't do it today, we can do it real soon.
Absolutely.
Okay. All right. Great. So you're going to talk with Ms. Shanahan. Then that addresses those two. I don't think there's anyone else on the calendar.
There is, Your Honor.
Oh, I was wondering who that unfriendly face was out there. That is, I'll show up when I feel like it, Miss Taylor.
So Ms.
Interesting.
Taylor is present. She said she did not. I called. I sent her an email. She responded to my email. She called me. She said she did not receive notice of today's appearance, today's calendar.
Okay.
So I told her, hurry up and get over there, and she's there.
All right. We'll get to that in a second.
Yes, Your Honor.
Thanks.